What's up, guys? Welcome. The volume's on. I checked. Welcome to Law-Splaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm. What is it? Small law firm in central Minnesota. And oh boy, do we have some really surprising and exciting documents to go over tonight. Man, I cannot wait. The legal arguments, the logical deductions. Really, the logical deductions are a thing to behold. They're marvelous, well-founded, thoughtful, and emphasis on the thought. Thoughtful conclusions that are being drawn from facts that are only existent in the minds of deranged lunatics, or are just flat out obviously wrong. So there's that. As you are probably aware, there were some filings late night last night that posted today. We have Rial and Toye's brief in support of sanctions and attorney's fees. We'll take a brief look at that. What? God, I was eating a Pop-Tart earlier. I think I got crumbs everywhere. We are going to have, their sanctions and attorney's fee requests, along with Marchi's lawyer, Sam Johnson, sanctions and attorney's fee requests. And then we're also going to have Lemoine's brilliant reply as to why Chris Slatosch should be deposed, which I can sum up for you now as in, the other side doesn't want me to, which means I have to do it. That's proof. So we've got solid logic, we've got bad facts, we've got all of this stuff going on. It was it's a mess. It's actually demotivating how dull these documents are. I don't like this part of the lawsuit. Can I be candid with you? We'll be candid. I don't like this part of the lawsuit. I think that's obvious, right? I know many of you are in the same boat. What I don't like about it is because of how Chupp handled the hearing, or rather didn't handle the hearing, there is no way to do anything faster than what's going on. And what's going on right now is a bunch of stuff that is probably going to get rubber stamped, but won't matter because the appeals court's going to relook at this. And so the appeals court's going to have to go through and redetermine all of this stuff, right? So that's frustrating. There's just nothing to do. And I hate that this is where we're at, because I really do think that Chupp completely screwed the pooch on how to deal with this TCPA hearing. And upon doing some pretty simple research on the 2nd District Court of Appeals down in Tarrant County, I'm pretty sure Chupp may have never actually fielded a TCPA, because he is not attached to any TCPA appeals. Not any of them that I can find. There are TCPA appeals which have Chupp mentioned in them in some other thing, right? Like he's mentioned in some other document or cited somewhere, but he's not in the case that decided the TCPA, which is baffling, because he logically should have had a TCPA hearing or two during his career. Like it seems like that would happen, but I don't know that it ever has. And if it has, somehow no one has appealed it, which is crazy. Crazy. But it's crazy because it's such an easy out for defendants, and because Chupp has been a judge for something like a decade, and finally because both sides are highly incentivized to appeal TCPA judgments. They just are. So the fact that he's not attached to any of them is just really, really mind-blowing in a way. But that being said, it's really frustrating because had this gone the other way, right? Had this gone the other way and Vic won at the trial court level, even though it would definitely be appealed, we would have just this massive onslaught of vitriol coming back this way. And so it's really weird because and they would be talking about how they're definitely going to appeal and this is unjust and all this stuff. Same things that we're saying here. That's the TCPA divides cases like this. This is how it goes. It's so prejudicial to either side, but specifically towards the plaintiff, right? Because if the plaintiff loses TCPA, their whole thing is thrown out and they've got all these fees that are tacked on, which is really crazy. It's really crazy to determine that a lawsuit is without merit simply because some judge decided there wasn't quite enough evidence to bring a case that were any other set of laws involved than the TCPA would be absolutely going to trial. Like that's an insane sort of thing to think about. That there is something where you go, okay, well, I need more evidence than what you brought, more than your notice pleading assertions, more than all of that. I need more than that. Even though in a breach of contract or in all of these other things, you would have plenty to say that on this thing, I need more because. And to put that burden on a plaintiff is really frustrating, we'll say. We'll say it's frustrating. But yeah, it's the law that we have. Well, Texas has. And it's what we're dealing with in this case. That being said, I don't like this part of the case because I know that none of this actually matters. What will matter is what the appeals court decides. That's what will ultimately matter. Now, the appeals court may agree entirely with Chupp, but Chupp's decision won't make that matter. That'll still be the appeals court making the final ruling on everything. So until that the appeal goes through, this is all just sitting there waiting for the moment when the argument gets to start back up. And that is boring. I don't like it. I'm not a big fan of covering the same documents with the same arguments. And these arguments are remarkably similar, and deficient in many of the same ways. But that being said, we are going to go through the 3 documents tonight. I think this will probably be a pretty short stream. And just so you know, there is no stream tomorrow because I will be on the Dick Show's bonus episode. We're going to do a Dick Tracks or whatever, dictation over the Dr. Phil tapes. So I'll be on along with several other people. Should be a fun time. But there will not be a live stream here tomorrow. So if you're looking for one, I apologize. I may go on Twitch later in the evening, but I don't know how long the Dick Show is going to go. I don't know anything about that. And so tomorrow I've just gone ahead and said no live stream here on YouTube tomorrow. Thursday, there will be a live stream. It'll be Q and I, and we'll be going through the Michael Drejka shooting. We'll be going through the Michael Drejka interview and the Michael Drejka not the trial, but the sentencing hearing. Because, again, wherever you fall in the Drejka shooting, I think it was a completely unjustified shoot for all sorts of reasons. But if you come to a different conclusion, that's fine. I'm not going to argue with you on it. That's my conclusion. But that being said, wherever you fall on it, what we can all sort of understand and agree upon are the several mistakes that he made in marshaling his defense. We can talk about those, talk about why you don't talk to police officers without an attorney, how different aspects of your immediate interview with police officers can go wrong even when you think you're in the right, and all of those things. Because that's what ended up getting him convicted, was how he dealt with the aftermath. Also the video. I mean, there's also the video where he shot a man backing up. That's a big, huge problem. But it's not dispositive of the case. That's the crazy thing, is you can still be in fear of your life from someone who's backing up. But Drejka really screwed up in how he dealt with it. So I'll have Q on. We'll be talking about that, talking about his show. I'm bringing on Q to discuss things as both an African American and a firm proponent of the Second Amendment and concealed carry. So we'll get that perspective as well. And we'll be just talking through it and seeing what's going on. So it should be a fun show. Friday, we've got Dollhouse Phil. Dollhouse Phil will be on Friday. If you're not familiar with Dollhouse Phil, he is a gentleman over in the UK who makes sex dolls. And so we're going to talk about I guess the business of making sex dolls. We're going to talk about the hurdles to making sex dolls and selling them, what it's like on a personal level, what it's like on a business level, if there are legal obstacles to it. We're going to talk about the social stigma and the philosophy of the sex doll, I guess, from his perspective. I'm going to ask him all kinds of questions. I'm fascinated by this trend. Of course, Drexel talks about sex dolls and sex robots being a crazy sort of market and what they're going to do to women and relations on men versus women. And so that's what we're going to talk about, or what I'm going to talk about with Phil tomorrow. I'm pumped for it, or not tomorrow, Friday night. I'm pumped for it. It's a conversation that's been a long time in the making. Talbot Links has been trying to get us to connect for a while. Finally, which is my fault. Finally, I reached out, and now we've got a show. We've got a show coming on Friday for that. I also talked with Doug TeNapel today, and at some point, Larry, and I are going to do another Chad Dad show. That'll be sometime in the near future. Not this week, maybe next week or the next one. I don't know. I gotta coordinate with their schedules and see when they're able to do that. So we'll talk about what's going on in their lives and what's going on in our culture. Always a fun show. So let's see. What else do we have? Other than that, we're just going to do this little show tonight. We're going to do this little show tonight. We're going to cover these documents. I hope y'all are excited. I think what I'm going to do is I'm going to start with Lemoine's documents, and I'm going to start with his reply in support of motion to compel deposition documents of Chris Slatosch. Then we'll move to Rial and Toye's their motion for attorney's fees and sanctions. In that, I'm not going to go through all of the exhibits. In fact, I'm only going to cover one of the exhibits, but it is the article from the Minnesota Lawyer that is about me. And I'm going to cover it, one, because the guy cannot effing spell my name to save his life. Two, he says he called me multiple times for comment and yet just decided to never leave a message. And three, there's some interesting opinions from ethics specialists in Minnesota in that document. And I think that's worthy of discussion. So we're going to go through that. Reveal the Pop-Tart. Oh, don't you dare accuse me of eating a s'mores Pop-Tart. Filthy. Absolutely disgusting. Oh, constitutional murder. You're lucky, man. You're lucky. No, strawberry. Strawberry. is what I have. Strawberry and brown sugar cinnamon are the only two Pop-Tarts I eat, except on rare occasions. Rare because they're limited to Christmas time. I will eat a sugar cookie Pop-Tart. I will eat a sugar cookie Pop-Tart. But, yeah. You want to fight? Look at it. Look at the pathetic icing job on this. This guy must have been running a little low. This is strawberry. You can see it's got the multicolored sprinkles. Not that stupid cherry garbage, which has all the pink sprinkles only. It's got the multicolored sprinkles. This is a strawberry Pop-Tart. Show of hands. How many of you keep your Pop-Tarts in the freezer? 1 for freezer, 2 for cupboard. 1 for freezer, 2 for cupboard. I'm waiting. Seeing a lot of cupboards. I'm not seeing a lot of freezers, but I am seeing a couple. You guys cannot honestly keep Pop-Tarts in the freezer. What is wrong with you? What is wrong with you? Why are you broken like this? Why are you broken on the inside? Oh my gosh. No. Oh. The package said to do it? No, it doesn't. If you put Pop-Tarts in the freezer, get out. Like, what is this? What is it? And I don't mean get off the show. You definitely stay for the show, but get out of like life or whatever. I can't believe that Pop-Tarts would go in a freezer ever. It doesn't make sense. Oh my goodness. Okay. The sugar cookie one tastes like a sugar cookie, and they're really good. They're really good. They're limited edition to Christmas time, so check them out. Check them out. No, get out of Life is Life magazine. You can't have your head buried in Life magazine. What are you talking about? Okay. Make an ice cream sandwich with 2 halves of a Pop-Tart. Ugh. 2 halves of a Pop-Tart? No, they give you 2 Pop-Tarts in a package. Just put 2 Pop-Tarts down. What is this? What's this world coming to? Why would you break a Pop-Tart in half to make an ice cream sandwich when you could make a full one with both tarts? Do you break bread in half to make a tiny little midget sandwich? No! Only Drexel makes midget sandwiches. Okay. Before we get fully started, I want to I got a couple gifts in the mail that I want to acknowledge. Very, very nice gifts from viewers. This is from Ben. I'm not going to say last names. No docs. And hey, I'm not going to say last names. You know why? There's an admitted mass media campaign of shaming against me and viewers. They just went ahead and admitted to it in the documents. So I will not mention last names on the show because I know that Lemoine and his legion of con sluts are out actually actively attacking me and viewers because they're that cool. So, good job, Lemoine. Oh, and for those of you that have read the document that we're going to read tonight, you'll notice, of course, that it says that they're conducting that there's a constant barrage of shame from the media intended to silence me. But what does that mean when the entire documents, the purpose of the entire document is to paint Vic Mignogna as me, to paint me as Vic, as interchangeable as one and the same? That means that they are literally admitting to conducting a media campaign to silence Vic Mignogna. That's what they're doing. Make no mistake, there is nothing else you need to know. He is supposed to die silently alone. And if he doesn't do it, they will go to NPR, they will go to Anime News Network, they will go everywhere they can to put him deadly silent in the ground. And they've admitted to it in their own filing. That's how embarrassingly disgusting these people are. You can't... How dare he? How dare he speak up? How dare anybody speak up on behalf of him? Don't they know? Don't they know that the weight of 200 women has come against them? Emphasis on the weight of 200 women. I mean, to be fair. So, yeah. So anyway, they're just admitting to it now, so that's cool. Okay, anyway, so this is from Ben. This is a book that he thought I would like. This is The Yellow Sign and Other Stories, which is the complete weird tales of Robert Chambers. It's Lovecraftian in style, and Ben noticed that I'm a fan of Lovecraft. So I haven't read any of this yet. I just got it, and I really cannot wait because I'm a big fan of Lovecraft's writing style, of the mood and tone of his stories, and I love that when I read Lovecraft, I dream, which is weird, but I do. So, yeah. So, thank you, Ben. I'm looking forward to reading that book. I also got. I don't know who this is from. They sent it on Amazon, and they sent a note. Let's see. Yeah, there's just no. I have no identifying info on this, but it's a gift of a couple movies, and it's I wish I could thank you personally because I don't know, but they sent Rare Exports, which is I've heard about this movie. I've never seen it, but this is a Christmas tradition for them. I'm looking forward to watching it. Seems great. And they also sent Alita Battle Angel, which I did not see in theaters, but I'm really looking forward to seeing. I heard it was really cool, great visuals, great, good story. All of that stuff. So I haven't seen either of them. Whoever sent that, thank you so much. I really appreciate it. I don't know who you are because Amazon didn't tell me. And I don't remember who sent me this. I don't. But somebody out there must know what this means. I don't know if this is like an ultrasound of an abortion or something. I don't know what it is. But I don't know. But this is what I got. So thank you for this. It's a sticker. It says DSP fans. So I don't remember who sent it. I'm sorry. It was in a box with some other stuff and it got separated. So, but here, just in case you missed it, DSP fans. There we go. I don't think that's someone's lower jaw. That's either a topographical map or an ultrasound or something. You can't lie like that. Okay, and I've got one more. Big ups to Sean Ranklin, I think is what's supposed to accompany that. Oh man, I left my ridge knife upstairs, didn't I? I did. Why? Why would I put it upstairs? Oh, I remember. Lady Raggeds was making me do stuff. Hang on. Okay. Am I familiar with DSP? I know very snippets. Something about he puts my grift game to shame. I know that much. All right. I don't know what's in this box, but the person who sent it asked me to open it on stream. Okay, let's see. So this is from Chris. I can't, again, I don't want to dox anybody. I don't want to, yeah, I don't want to mess with, I don't want to have anybody mess with. So this is, what is this? What is this? This is a brand new brew. Okay, so this is from the Buried Acorn Brewery in Syracuse. Let's see. Okay. 1 can of Full Restore. This ale is made as a tie-in for the convention this weekend. Buried Acorn Brewery in Syracuse, as well as the staff at Retro GamerCon, would love to get your live thoughts on this new brew while we... Okay, so the rest of this letter is saying how this is a gift, and there's no expected reciprocity or anything like that. This is just from an individual. Let's see. So this is Full Restore brew here. Let's see if we can do that. It's super effective. Here we go. Let's see. As for the rest of your letter, Chris, which I'm not going to read all this live, obviously, but yeah, man, you've got my email. Let's talk about it. Well, the brewery didn't send me the beer, so I didn't dox the brewery. Let me get this. We've got electrical tape on this because it's electric. Now, I am typically not a beer fan. I don't really like beer. So we're going to give this a shot, though, because I also don't turn down gifts. I'm not rude. And just because I typically don't like beer doesn't mean I won't like this beer. Let's see. According to the Surgeon General, women should not drink alcoholic beverages during pregnancy because of the risk of birth defects. Oh, okay. I don't know. I thought they were going to stop at beverages. Seems... Phew. So this New England style pale ale brewed with Comet and Mosaic hops. Cheers. We hope you enjoy our brew. Yours digitally, Retro Boy. So let's try this. This is a 5.5% alcohol by volume beer. Okay. Are you supposed to nose beer? Smells like beer, but not like overly hoppy beer. What else is in this? That's not terrible. It doesn't have a lot of beer flavor. There's something really... It's got almost a fruity sweetness to it. I don't know what it is. Reminds me of like Mountain Dew with beer in it. That doesn't sound good, but it's better than I thought it would be. Not bad. I'm gonna go throw it in the fridge, and then later in the show I'll grab it, and we'll do. Later in the show I'll grab it with a cold review. Be right back. Bruh. Okay, I'm back. Okay. So, I did notice that while coming back, that it does have that hoppy beer aftertaste that's in there, which I'm not saying that is a bad thing. For me, it is a little bit of a bad thing because I'm just not a beer fan. I don't like the flavor of hops. I like mead. Mead I like just fine. It's the hops in beer that I just don't like it, but it does have a distinct beer flavor to it, especially in the aftertaste as it sits around in your mouth. So just to complete the review, but let's hit these chats and then let's do the let's get into the documents, and we'll go back to that can of beer in a little bit when it's colder. When it's cold. Dustin Fritzfar says, well, hello there, Nikki. Did you miss me? Yes, I mispronounced calling you Dustin, or I missed calling you Dustin Fitzfar all the time. Well, too bad, Nikki, because you can't be rid of me that easily, Nikki. So buckle up, you grifting fake lawyer. You're definitely getting 20 of my dead president papers. Ooh, thank you. Thank you. You can call me Al says, Jim is a spook. He admitted as much in the David Stay stream. I bet Jade is a juicy girl, and why he loved Russian vodka so much is when he was undercover in Russia, he got used to it. Can't change my mind. Well, maybe that's how Trump got elected. Morty J says, fudge Pop-Tarts in the freezer are amazing. Fight me, Nikki? No. No to both. I turned down your fight, and I turned down your fudge Pop-Tarts being amazing. Andy M says, but Nick, Drex is cooler than you, so tiny sandwiches it is, lol. Dustin Fitzfar, you will not, I'm going back to the old pronunciation. Dustin Fitzfar says, they can come and get me, Nick. They will find I don't have a Twitter or a Facebook, so they will need to come to my front door, and I have a cavalry saber waiting. Whoa, watch out. If you come to his front door, he will mount a horse and slash at you from it. Slash at you from it. So that is great. Okay. Should we get into these documents? Let's get into these documents. So here we have the reply in support of the motion to compel deposition and documents of Chris Slatosch. Obviously, Lemoine is trying to get this reply in front of the judge before his proposed hearing on the 7th, which has been opposed by the plaintiff. And for all of Lemoine's whining, that's not going to get him in front of the judge. Like, he's not going to just get in front of the judge because he whines about it, as he tries to in this document. So, but let's take a peek. Is that centered? It's not centered well. A little bit better. Okay, reply in support of motion to compel deposition and documents of Chris Slatosch. Defendants, Rial and Toye, blah, blah, blah. Respectfully show the court as follows. I'm sure that they'll respectfully show this. If Chris Slatosch's deposition is irrelevant, then plaintiff has no need to show up. Does not need to spend any time or fees worrying about what Mr. Slatosch might say. If you know anything about law at all, you know that this is the stupidest line you could say, right? You know automatically that this is the stupidest line that could be possibly written about this deposition. Well, if they think it's irrelevant, they can just not show up and not spend any time worrying about fees. Because, of course, just because it's irrelevant doesn't mean that you're not going to attempt to use it to cause trouble, that you're not going to bully and harass someone, that it's not a perjury trap, that it's not all sorts of things that you want it to be. It can literally be factually and legally irrelevant to the questions at hand, which it is. Which it is. But they're trying to get something else out of it, which they're going to, again, they're just going to say it. They're going to say it all in this document. Wes Nilechan says, my sweet Lemoine coon may not be able to inflate a balloon, but he can inflate his billable hours. Oh, yeah. Well, yeah. We'll see about that. But the fear driving this unnecessary motion practice, including seeking sanctions on a new objection, only confirms that the court should hear from Mr. Slatosch. They should have to do it because they're opposed to it, so then it should happen. That's the legal reasoning. That's the logic behind this whole thing. They don't want it, so that proves the court should hear it. Which, if you apply that in reverse, you could say that means that the TCPA's discovery stay necessitates the discovery should be shown, should be engaged in. Because if they don't want to do the discovery, then that is just proof that the court needs to see it. The motion to dismiss, if you say it's a frivolous lawsuit, if they're so afraid of fighting this lawsuit, well, it means the court should, it's proof that the court must see the entire case because they're afraid of fighting it. Do we see how the logic breaks down when you just take an A to A, B to B comparison of any other event? Of any other event in law. Well, the opposing side opposes it, so then it must be necessary to do. Oh my God, we've just solved every lawsuit. Every plaintiff automatically wins. Every plaintiff automatically wins because since the defendants oppose what the plaintiff is doing, well then what the plaintiff is doing must be correct. Automatically. We've solved the court legal system. Thank God. Thank God. We can now move on to bigger and tougher issues. Let's figure out how to abort Texas lawyers. So that's their solid legal reasoning. The new objection should be overruled, and if sanctions are in order, it is only against plaintiff's counsel. Why? Plaintiff counsel didn't ask for any of this. Argument and authority's new objection is without merit. Without merit. See plaintiff's response to defendant's motion to compel deposition documents. First amendment, blah, blah, blah. Okay. Plaintiff abandons his subpoena distance objection to advances the new and legally incorrect argument that the TCPA suspension of discovery survives the October 4th order. I actually said this. I'm not convinced that that's the best argument. That the TCPA stay exists. I know why they're making the argument. They're making Lemoine either admit that the TCPA is done and therefore it's appealable, or that the TCPA is not done, in which there's still a discovery stay. That's what they're trying to do. I'm not a big fan of that argument. I think I made that pretty clear yesterday. I don't think that's the greatest legal analysis or reasoning, but that's, you know, it's an argument for sure. And it's a trap. It's a trap. Side-by-side comparison of the order and TCPA answers whether discovery suspension is in effect. It actually doesn't, though. Order is, therefore, the court grants TCPA motions, plaintiff Victor Mignana's claims against defendants Funimation, Marchi, Rial, and Toye are thus dismissed with prejudice. And then TCPA 27.003, except as provided in 27.006b. On the filing of a motion under this section, all discovery and legal action is suspended until the court has ruled on the motion to dismiss. But if the court has ruled on the motion to dismiss in its entirety, which is the argument that they've put forth to the appeals court that the court has not ruled in its entirety on the TCPA motion, there's still some outstanding thing. One or the other is what they're trying to force. Again, not a good argument, in my opinion, but it's what they're trying to do. And Lemoine is flailing against it because it doesn't make sense, because the TCPA doesn't make sense. Now, I think the better argument is that they're outside of any discovery period. And maybe I kind of wish they would have argued in the alternative that even if the TCPA stay was no longer in effect, that they're outside of any sort of discovery period and thus need to request permission of the court to add additional discovery costs and time to the court's docket. which is otherwise unnecessary, which would allow them to petition the court to do these things and then have this argument over whether or not they should be conducting additional discovery or just filing their documents as Chupp told them to do. But, you know, it doesn't matter. We're now past that date, and now they're arguing over this thing. So the court has ruled on the motion to dismiss. Therefore, the suspension is over, and the moving defendants were not required to seek relief under 27.006B. Here, let's see what the footnote says. If his plaintiff now concedes there's not a final judgment, he should promptly dismiss his interlocutory appeal. See, Lemoine is recognizing the issue here as well. It's an issue for both of them, and one that only the court can figure out. But here's the thing. There's a rule that says that the early filing of the appeal is fine. That it'll just perfect when it perfects. As far as the interlocutory nature of it, it's only interlocutory insofar as the court determines that the final ruling on the sanctions and attorney's fees prevent the rest of the case, the appeal from going forward, or aren't resolved prior to the appeal being heard. So we'll see, of course. The cure for a trial court's violation of the discovery suspension is a mandamus to the Fort Worth Court of Appeals. This would put plaintiff in a double bind of arguing to one panel the appeal is ripe while arguing to a different panel that no final dismissal has been ruled upon, in addition to spending thousands of dollars to avoid an allegedly irrelevant deposition. But if it's irrelevant, then it's your thousands of dollars. Okay. And then number 3, nor does plaintiff's interpretation make sense considering if the court had granted the motions only in part, there's no basis to stay discovery until the court ruled on the fees as to the dismissed claims, absent a timely filed interlocutory appeal as to the denial of a TCPA motion to dismiss. Maybe. Maybe not. We don't know. We don't have case law to actually support this. If you notice, there's a lack of citations here. And this is the thing that is going to be lost on this. Now, while I say I don't like the argument, there isn't authority either way on this. And if there were, Lemoine would have put it in his argument. Presumably, so would Ryan Sellers have put it in his argument. But there isn't actual authority on this. It's a weird period that isn't guided by a lot of appellate court or Supreme Court guidance. There just isn't much to do with this. TCPA is a mess. It creates an entirely new special procedure with a whole new set of rules outside of every other thing that the court deals with. And so if there's not guidance on it, then it's an argument. This new objection has no merit and is a desperate attempt to prevent the cross-examination of Mr. Slatosch. I don't think it's a desperate attempt. I think it's just a pretty straightforward attempt. As argued below, if leave of court is required, the following sections lay the factual predicate for such leave, which is requested in the alternative. Having invoked Texas Civil Practice and Remedies Code 10.001 and on, the court should award moving defendants their reasonable attorney's fees as a prevailing party under Section 10.002C. Court may award to a party prevailing on a motion under this section the reasonable expenses and attorney's fees incurred in presenting or opposing the motion. There's no reason to invoke sanctions other than a transparent attempt to regain the high ground that is irretrievably now lost. Number 5 says, by the time an oral hearing and briefing is completed, plaintiff will spend the same amount of time that Mr. Slatosch's deposition would last. Well, then that's why you do it then, right? That's why you just automatically let them do it. Plaintiff can avoid costs by not attending an irrelevant deposition, which it's always wise to do that. This is sound legal advice from Wheezy here, is that if your opponent is doing something, make sure you don't engage it at all. Don't do that. If they were to do this, right, what Lemoine is advocating here would be malpractice. The opposing side is conducting a deposition of one of our key witnesses, but we're not going to go. Malpractice. That's it. That's all you need to know about that. That would be malpractice. And anybody whose attorney says we're just not going to go to the deposition of our key witness by our opposition is is committing malpractice. Also, that you know what this means is that Lemoine's lying to the court straight out of it, constantly. And this is a repeating pattern. Lemoine lying to the court over and over. Or being too stupid to understand that he's just wrong, which we'll get to as well. Unfortunately, that's plaguing Sam Johnson also. Plaintiff concede he does not have to attend the deposition. And if Mr. Slatosch's testimony is irrelevant, there's no reason for him to attend. This resolves his drive-up costs, and plaintiff can make relevancy objections to Mr. Slatosch's testimony at the evidentiary hearing. Now, here's the interesting thing. Of course, he's not just talking about their own costs, because they're going to impute the cost of this deposition onto the plaintiff. That's obvious. They're not just driving up costs for the plaintiff, they're driving up costs for themselves to put onto the plaintiff. Another disingenuous moment by Lemoine. The cost issue is also undermined by plaintiff's desire to have oral argument on this issue, which only further drives up the costs. While moving defendants are confident in their written argument and would prefer a telephonic hearing to avoid unnecessary travel time, counsel will make themselves available at this court's direction. The court should also notice that plaintiff has not proffered any evidence that any type of attorney-client or attorney-work product privilege exists that would prevent Mr. Slatosch's testimony, including any basis for confidentiality. They don't have to at this point. They can just oppose it on other grounds. They can oppose it on other grounds. They don't have to tell you. The undersigned has conflicts on Thursday a.m. 9 to 9:11 a.m. hashtag never forget prior hearing, and Friday 9 to 12 p.m. pre-scheduled family issue, but will otherwise make himself available. Plaintiff has no standing to assert harms to Mr. Slatosch. Plaintiff concedes that he has no standing to invoke hypothetical harms such as costs on behalf of Mr. Slatosch. Mr. Slatosch so chooses, he can contest the subpoena, but Mr. Slatosch's alleged inconvenience is not a basis to avoid the deposition. But Slatosch doesn't need to contest the subpoena yet. He doesn't have to. And to demand that Slatosch, look at what they're trying to do over and over and over again. Look at what they're trying to do. They are trying to punish Chris Slatosch because he made them look bad. They're trying to punish everyone who made them look bad. Why they've run to the media. That's why they're trying to get me in major media. I have no idea why you would want to put me in major media pieces, but they're trying desperately to do so. It's why Jamie Marchi has acquired funding for being a victim by the Time's Up Legal Defense Fund. Jamie Marchi, her hair was touched. Time's Up Legal Defense Fund, defending rape victims and liars, named Jamie Marchi every day, apparently. But this is why they're doing it. They have to punish. Punish, punish, punish. Hey, Huber, I know you're trying to avoid the punishment. I know you're trying desperately to do it. We'll see. I wish you the best, man. You seem like a good guy. I wish you the best. But I think they're probably got knives out for you as soon as it's your turn. Don't forget. They have knives out. Slatosch made them look bad. He put up an affidavit saying exactly what they did. The whole world can read it from his mouth. From Chris Slatosch's mouth. You can read that Monica Rial and Ron Toye, this is a fact, called Chris Slatosch and pressured him to remove Vic from Kamehacon. No matter how smart Judge Chupp could be in flat out ignoring the fact that an owner of a convention under oath stated that Monica Rial and Ron Toye engaged in a conspiracy and conspired with other attendees to sabotage the Kamehacon show because Vic Mignogna went, because Chris Slatosch honored a contract that he had made before he contracted with Monica. By the way, Monica begged to go to Kamehacon after Vic was signed. After Vic was signed, Monica asked to go to Kamehacon. There's no way to deny the owner of Kamehacon was put into a position where he was required to enforce a legally binding contract. And because of him wanting to enforce his legal obligation, Monica Rial and Ron Toye threatened to cause damage to his show and then did it. They did it. Nothing can dispute that. No matter how much they want to pretend it didn't happen, the entire world can see that Monica Rial and Ronald Toye are liars. They lied about doing this. When it was pointed out, when the text messages were brought up, their tune started to change a little bit, but they still maintained it never happened. And then Slatosch comes out and puts in his affidavit that not only was it the text message, but it was a phone call with both Monica and Ron. They lied. Lied. Over and over and over. They accused me of lying, and I was telling the truth. And you know who backed it up? Chris Slatosch. Why do you think they want to go after him? Why do you think they want to punish him and cost him money? Because they lied and got called out on it. Okay. Plaintiff fails to understand the evidentiary hearing is about the amount of the sanction. Unless plaintiff is willing to stipulate to the sanction and the amount and waive his appeal rights, moving defendants must lay an evidentiary predicate for the amount of sanctions they seek. Actually, I don't know that they have to do that. You've decided that you're going to do that, and that's fine. The sanctions are as the court sees appropriate. There's no evidentiary requirement for sanctions written into the TCPA. There's actually not even a listing for an evidentiary hearing on sanctions in the TCPA. The motion to compel citations to Landry's Inc. versus Animal Legal Defense Fund explains the necessity of an evidentiary hearing, except you'll admit that that's not from Tarrant County and that there's no authority on this from Tarrant County in just a little bit, including providing evidence for the court to examine on multiple factors such as whether the lawsuit was frivolous and or brought for vindictive purposes. They don't have to address this. This is your argument, but this isn't necessarily the way it goes. It's how it was dealt with in one case, and there's little other guidance, and it's from a different district. Unsurprisingly, the response does not mention Landry or any case law. Instead, it engages in wishful thinking that Mr. Slatosch will testify in plaintiff's favor under cross-examination. If Mr. Slatosch will only testify in favor of plaintiff, then he is safe in not attending the deposition, which further eliminates his cost objection. Obviously untrue. This is just disingenuous legal writing. There's ample evidence in the record to justify Mr. Slatosch's deposition. Plaintiff errs in the assertion that moving defendants... That's errs, I know, it was a joke. The moving defendants did not lay a factual predicate for cross-examining Mr. Slatosch. Mr. Slatosch and Mr. Toye offered opposing testimony which sets up the basis for the deposition. Only if the deposition is relevant. This is... Look at what they're trying to do here. He's trying to... Sorry, I realize that you can't see when I type in. Opposing testimony which sets up the basis for the deposition. Again, disingenuous legal writing. This isn't about the motivations for bringing the lawsuit. This is, in summary, Rial and Toye individually and jointly told me Vic was a sexual predator who would be criminally charged before Kamehacon and urged me to breach the contract with Vic. This is a material fact related to the TCPA. Good job chupping that one up, Chupp. And then Toye, did you urge him to terminate Vic Mignogna's appearance at Kamehacon? No. Yes, a self-serving statement by a defendant. That's solid conflicting testimony. Remember how just disagreeing with testimony does not set up any basis for discovery or anything else. Remember that. That was chanted over and over by the other side that disagreeing with the testimony, disagreeing with something is not a basis for a legal conclusion that there's a dispute. That's been said over and over. But either way, this is not at issue in the sanctions hearing. Not at all. This breach is in relation to the TI. And good job reminding Chupp that Slatosch said all this. Good job. I mean, just put it in the record for the appeals court, too. It's good. Further, and absent from Mr. Slatosch's affidavit is a causal statement as to why his company, Silverfire, breached the contract with plaintiff. The closest he comes to the state, Silverfire did breach its contract with Vic by canceling his appearance. And, but what he does not say is why Silverfire breached the contract. Except, I mean, the entire affidavit states why he did it. Because he got pressure from the losers. And if Silverfire breached this contract because of Miss Rial and Mr. Toye, it was a grievous oversight by the drafter not to include such a critically important statement. It's not an oversight. Everyone reading that affidavit knows what happened. But the more likely scenario is the first draft of the affidavit sent to Mr. Slatosch contained causation language which Mr. Slatosch rejected. Baseless. Absolutely baseless assertion here. Any such communications, including rejected drafts sent by plaintiff and his agents to Mr. Slatosch, put plaintiff on notice of the frivolousness of plaintiff's tortious interference claims. This is baseless. There is zero basis for these assertions. None. He's literally making it all up. Literally making that up entirely. Out of whole cloth. No citations. No evidence, nothing. Let's see. Andrew Morgan says, no need to read until the end. Well, I'm going to read it now anyway. Hey, Nick, just got my first check as a real estate agent. Hey, congrats, buddy. Here's the money I owe you for grifting me the last couple months plus a late fee. Cheers. Hey, thanks, man. I appreciate that. Tillip, did you do a sticker? That's a salt shaker. I don't know if you guys know this, but there are also super stickers. I don't know how they work, but you can do stickers on your super chats or whatever. I don't know what that means. Considered in that context, considered in the context I manufactured out of thin air, plaintiff's objection to relevance is both wrong and begs for Mr. Slatosch's deposition to get to the truth. Well, look, under this situation that I completely fabricated, the plaintiff is wrong. God, it is also irrelevant. Is both wrong and begs to get to. Is also irrelevant whether Mr. Slatosch, quote, did not believe that either of the moving defendants interfered with plaintiff's contract. Any inquiry on Mr. Slatosch's belief would call for Mr. Slatosch's legal conclusions would not be confident evidence in determining any facts of consequence remaining in this legal proceeding. That's not untrue. That's not untrue. Because the second part of that statement matters. If plaintiff knew, because Mr. Slatosch told him or his agents that the moving defendants had nothing to do with Silverfire's breach of contract with plaintiff, which you have made up. You have manufactured that. That fact doesn't exist. It's a fact, not an evidence. There is no fact that suggests that this is true. Yet he attempted to convince this court otherwise. It would cement the frivolousness of his tortious interference claim. There is no foundation for your claim. Notice, C. Landry, quote, we also have evidence of frivolousness in that some of Landry's claims lacked any legal or factual basis. They have evidence. Here we have no evidence. We have a manufactured scenario by Lemoine. He's trying to drive up costs. That's all he's doing. To put it bluntly, that is exactly what plaintiff's counsel said at the TCPA hearing, where he quotes Ty, we have the real devastating evidence, which is Mr. Slatosch with Kamehacon. In Slatosch's affidavit, here it is, I've got it. No, I don't. In Slatosch's affidavit, he flatly states that Rial and Toye verbally urged them to dump Vic Mignogna. They threatened him with having the other voice actors pull out of the convention. They said there were criminal charges pending, that they told him that he would be charged before the convention, and he said, okay, I'll drop him, and he dropped Mr. Mignogna. That's from the affidavit. Sheldon, i.e. Mr. Slatosch, the one person who personally knew why he refused to go forward with the alleged contract. So once the impermissibly speculative evidence from Kahn's affidavits is disregarded. So he's quoting Van der Linden versus Kahn here. There is simply no evidence, let alone clear and specific evidence, that but for the message, any contracts between Kahn and Sheldon would have gone forward. There's evidence. It's the affidavit. The affidavit is pretty clear on this. So this premature legal objection is A, based on the assumption that the deposition question is asked in an objectionable format. It won't be. And is B, legally incorrect? Okay. So 13C, excerpts of TCPA transcript. Why don't you just go ahead and cite to the affidavit? In the heat of the moment, Mr. Beard may have over-exaggerated. No, I don't think he did at all. But Mr. Slatosch's affidavit does not say he dropped the plaintiff because of Miss Rial and Mr. Toye's actions. Why Silverfire dropped the plaintiff remains a mystery that is a critical piece to the sanctions hearing. Oh, yes. Big mystery. It's actually not a critical piece to the sanctions hearing at all, because the court didn't consider the affidavit, and the court dismissed what factual issue that resolves. So, again, Lemoine's walking this thin line where he is trying to get the court to flesh out more of its argument for the purpose of appeal without asking for reconsideration. He's trying to do that because he knows what's going to happen if this goes to appeal and the court looks at all at that affidavit as part of the case. If they decide that affidavit's part of the case, he loses. Finally, the circumstances under which the affidavit was notarized carry the stench of falsity. Ty has already actually addressed this in court, so this is disingenuous as well. Mr. Slatosch lives in Ector County, which is over 400 miles from Beard's office in Smith County. Mr. Beard notarized Mr. Slatosch's affidavit. Perhaps Mr. Beard drove to Ector County or Mr. Slatosch drove to Smith County, or they met somewhere in the middle, but the affidavit's sudden withdrawal after moving defendant's counsel questioned the notarization lends credence to something being, quote, rotten in Denmark. Ty addressed this at the hearing. What's your brain doing? It's in the transcript. Mr. Slatosch, however, can clear these issues up. It's in the transcript. It's in the transcript that you've cited. It's there. It's right there in the transcript. Ty said, I thought I could notarize him over the phone. I was incorrect. So I withdrew him to correct that issue. It's in the transcript. In the alternative, good cause exists to determine if plaintiff tried and failed to perpetrate a fraud on the court. Assuming arguendo that the TCPA suspension remains in place, moving defendants seek leave for a 2-hour deposition of Mr. Slatosch along with the production of documents sought in the subpoena. Moving defendants intend to take the deposition via teleconferencing, which will allow plaintiff to participate without traveling to Ector County. Good cause exists for the serious reasons articulated above for the court to hear Mr. Slatosch's testimony so that it can properly evaluate the amount of sanctions against the plaintiff. It beggars belief that Mr. Beard believed he could notarize an affidavit without the witness present. If Mr. Beard had never met Mr. Slatosch, you know he met Slatosch. He was at Kamehacon. And is simply talking to a voice on the phone who claims to be Mr. Slatosch and then notarizes the affidavit is inexcusable. He has met Slatosch. He's met him. He was at Kamehacon. You're making things up again, Lemoine. The only harm plaintiff can credibly assert is costs, which he can avoid by choosing not to attend and committing malpractice. That's fine. That's fine. And that's not true because you're going to impute your own costs upon the plaintiff. You're going to ask for them. Thank you, Mr. Say What Now, for getting my reference. Okay, say request the court to grant the order. Let's see if this... I wonder if they included the affidavit. Shockingly, they didn't include the affidavit in this filing. Huh. Weird. They talk about what's in the affidavit or what's not in the affidavit. They don't cite it. They don't cite it at all. They just cite the TCPA hearing. And only in part. Not the part that actually addresses the factual matters in this case. So, good job. Solid work there, Lemoine. Literally a fraud on the court going on right here, where he has made up a set of facts and is asserting them as true without foundation or evidence. Facts that are opposite to what the reality is. It's crazy. He's relying on the laziness of Chupp. This. Oh, cool. Sorry. I'm done with this document. Now, I hope you guys are ready for the next document. I went through the next document, which is their reply in support of their their motion for sanctions and attorney's fees. I went through this document very carefully, read it, assessed what was the heart of the document, because the PDF is 281 pages, okay? Because this is what Lemoine is doing. He's driving up costs. Show the last page of what? Of this document? This is the last page of this document. He's driving up costs. That's what he's trying to do. But I went through and I did yeoman's work. And I redacted everything that's not important from the document. I've done this as a service to you. Because I don't like people who sit there and fluff themselves, right? So I have redacted everything that's not important to the legal argument of Lemoine on why, on the attorney's fees and the sanctions. So I hope you're ready for that. So, if you guys will humor me, we'll go through it. This shouldn't take too long. Okay, so we've got Victor Mignogna versus Funimation Productions LLC, Monica Rial, Ronald Toye, and Jamie Marchi. Monica Rial and Ron Toye's brief in support of sanctions and attorney's fees pursuant to the Texas Citizens Participation Act. Okay, we got here. Nick Rekieta. GoFundMe, Rekieta, GoFundMe, GFM, Nick Rekieta. Rekieta, Kiwi Farms, Nick Rekieta. Rekieta, Kiwi Farms, Rekieta. Kiwi Farms, Rekieta, GoFundMe. Hey, who's this handsome guy? Kiwi Farms. Rekieta. Rekieta, go, GFM, Nick Rekieta, GoFundMe, Rekieta. Let's see what else we got here. Rekieta, GFM, and that's it. There you go. I distilled the essence of Lemoine's legal argument. Do you know how much work that took? I distilled the entire essence of it into everything that matters to them. And if you notice, it ain't Vic. It ain't Vic at all. So that's it. And if you think I'm going to sit here and read 13 pages of Lemoine's whining about me and the GoFundMe and the Kiwi Farms and lying openly to the court about literally all of it, nah, not going to humor him. I'm not going to read that for him. We'll just put it down to all that matters. I think it's best summed up on what page was it? What's the best page for it? It's right here. That's the best page. And yes, we are going to show the GoFundMe. Don't worry. Here's the GoFundMe amount. $258,365. Thank you to Anonymous. Oh, wait, no. Anonymous, and Kyle Martin. Also, Robert Sponsor, William Bishop, Steve Carolin. And I think these were all yesterday before that. So thank you. Thank you very much for your donations. We will be doing the GoFundMe gag through Sam Johnson's filing as well. But for the purposes of Lemoine's filing, I wanted to condense it into one because I don't want to spend a ton of time on his filing, in which he flat out lies to the court. He keeps saying that I am somehow representing or an agent of Vic. Hey, Jay Sean, I don't represent Vic. I'm not Vic's counsel. I'm not Vic's agent. I'm not Vic's PR person. I'm not Vic's media specialist. I'm not paid by Vic. I'm not employed by Vic. He doesn't get to ask me or tell me what to do. Nothing like that happens. He's never watched the show as far as I know. He has no idea what I say. He has no connection to what I say. No matter how hard you lie to the court, it's not true. You're a liar. You're a liar. I've never represented myself as representing Vic. I've never held myself out to be his agent. You don't get to impute liability upon him for my words. You don't get to do that unless I hold myself out as his agent, and there's both. And people reasonably believe that I am his agent based on my representation that I'm doing so. You don't get to just decide I'm the agent. You can call me a liar, but you have no evidence to show otherwise. But what you've done in this filing is you posted a picture of me and Vic in Hawaii, where we happened to be at the same place, and conveyed it as Vic and I were vacationing together in Hawaii, which is not true. I was vacationing in Hawaii with my wife. Actually, that's not true either. I wasn't vacationing in Hawaii. I was working in my capacity as a journalist covering HawaiiCon, interviewing people, and also networking for my show, meeting other people to delve into other subjects when this inevitably dies down. So you can say that I was vacationing in Hawaii with Vic Mignogna. That's not true. That's a lie. You flat out lied about it to the court. You've misrepresented a picture in which we did happen to be at the same convention. I was a media guest of the convention. He was a signing guest at the convention. That would be like saying that when Vic and Monica appeared together, they vacationed together. After Vic's alleged assault of Monica, she vacationed with him personally at several conventions for the next decade. How about that? Is that true? I'm sorry that your brain is broken. I'm sorry that a mosquito skin raped you and that caused you to have a broken body and brain. I am. But you don't get to just lie about things and make them up. It's not how this works. Okay. So that's the GoFundMe. Like I said, we'll go through that when we get to Sam Johnson's in just a little bit. But we're going to skip over. I'm actually going to skip over all of his exhibits except for, what page was it? 1-7. We're going to go through this article real quick. So here is a picture of me and Vic in Hawaii. This was tweeted by Stan Dolan. Yes, that is a picture in which I am standing next to Vic as we happen to be in the same location. I did not accompany Vic to Hawaii. I did not ride on a plane with Vic to Hawaii. I did not ride home with Vic from Hawaii. I didn't stay in Vic's room or anything like that. I was at Hawaii with my wife. I was a guest of HawaiiCon. And a media guest of HawaiiCon, I should say. And Vic was a signing guest of HawaiiCon. In fact, I believe he was their headline guest for voice acting or anime or whatever it was. If I've got that incorrect, I apologize, but I believe that to be the case. Kazma says, gosh darn it, that was good work. Here, you earned it. Hey, thank you. And then CE says, dang, I don't think you've ever mentioned the GoFundMe this much in a single stream, but Lemon Boy types it that much for an argument why he needs money. Yeah. You know. There you go. Okay. But did Vic touch your hair? Sorry, pull. No, I tried. I tried to get him to touch my hair and he wouldn't do it. Wouldn't do it. Okay, so this is from Minnesota Lawyer. And this photograph was distributed on Twitter on September 26th. It shows Vic Mignogna left, the plaintiff in a defamation suit against 3 people in a company that he says conspired to end his career as an anime voice actor by accusing him of sexual harassment and assault. And Nick Rekieta, the Minnesota attorney who raised more than $250,000 on GoFundMe to pay for the suit. Submitted photo. Okay. And this is written by Kevin Featherly, October 3rd, 2019. Kevin, how in God's name did you spell my name right here in the photo caption and then go on to ruin it for the rest of your article? What the hell is wrong with you? Oh my goodness. I don't know Kevin Featherly. I'd like to talk to him though. I wish I would have known he was calling me. Like I wish he would have left a message so I could talk to him about this. But no. Felipe Mouve says, Nick, Lemoine has to be held accountable for what he is doing now. You said yesterday the gloves are off. We need blood on the other side. Oh no! No, Felipe, you can't say that because they will interpret that as another death threat. That apparently is a death threat. Everything's a death threat. Ah, dang it. Have your intern check DMs? Okay. All right. Mithrin Emrys says, prediction. Lemon Boy's estimation of fees and sanctions will add up to about the amount of the GoFundMe. Just a feeling I have. Oh, it's like, it's shockingly and astonishingly close. Not on the fees and sanctions, just on the fees. On the fees. But we're not going to go through it. I'm not going to point it out. He said, I'm not going to read it. It's all lies. It's an absolute lie. His billing's a lie. All of it's a lie. And he knows it. Okay. So here's the article. Minnesota attorney plays soldier's role in anime war. A rural Minnesota attorney has played a pivotal role in what has been described as the American anime movie industry's first major Me Too challenge. And then here is the... Here we go. Nicholas Rekieta. An I? R-I-K? Of Spicer, Minnesota has leveraged his popular and potently populist potently populist YouTube channel to solicit more than $249,000 in donations for a GoFundMe legal defense campaign. The money is helping voice actor Vic Mignogna pay a lawyer in Texas to sue 2 women who took to social media to accuse him of inappropriate behavior towards women. 2 women, a cuck, and a company. Why is this so hard? He has sued arguably more men than women in this case. But okay. The fiance of one of those women was also sued, as was Funimation. But that can't get in the way of the narrative, right? So you have to put that in the next weird short paragraph. The Texas-based anime film distribution company that dropped Mignogna's contract after the allegations went viral in January. The entire case is playing out in Dallas. Mignogna sued the 4 defendants on 20 counts of defamation, conspiracy, and tortious interference. 17. Get your facts right, Kevin. 17. They campaigned and conspired to derail Mignogna's career as an English voice actor for Japanese-made cartoons, he claims. Chinese cartoons, get it right. His legal gambit appears mostly to have fallen flat. A judge dropped 15 of the charges on September 6th. 12. 11 days later, the judge sent the 5 remaining counts into mediation, scheduled to begin on October 3rd. That's actually a correct statement. It's just... The drama began almost immediately after the release of Mignogna's latest feature, Dragon Ball Super Broly. Cartoon, with Mignogna as the title character, grossed nearly $13 million in its first 3 days, making it one of the most popular anime features ever released in the United States. Mithran Emra says, almost forgot I cited your channel in the paper I'm writing for my supervised research paper on defamation. Oh, good. Hopefully your professor hates my channel. That'd be great. One day after its release, an anonymous tweet from it's not anonymous. Allison Cook is Han Leia. That's not an anonymous tweet. From someone dubbed Han Leia makes it also not anonymous, even if you didn't know her name. Accused Mignogna of being a homophobic, rude a-hole who has been creepy to female fans for over 10 years. Monica Rial, herself a voice actor, reposted that tweet, retweeted, reviving rumors that had swirled around the actor for years. Oh, no, wait, did Monica's retweet revive the rumors? Oh, that's brutal. That's a sad assessment. They could cite this article in their, if they go back on appeal, they could just bring this article in as evidence that Monica's tweet caused the damage. Eventually, the post got shared more than 4,000 times. It launched the so-called kickfix social media movement in which users unleashed a torrent of vitriol toward the actor. You know, and I'm picking on Kevin here, but really this is a relatively fair article. I don't want to besmirch it. It's a relatively fair article. I'm just picking on him on minor things. Like R.I.K. Oh, it burns me up. On February 11th, Funimation dropped its contract with the actor, and a bevy of anime conventions canceled Mignogna's paid appearances. Mignogna initially was both apologetic and defiant, saying the charges were untrue, but apologizing to anyone who felt he had been out of line. He promised to act differently in the future. That didn't quell. No, it didn't. Despite what Monica and company said, that didn't fix it. Oh, man, weird. The apology didn't fix it. Didn't quell the thousands of anime fans who rushed to Mignogna's defense, sparking an online flame war, flame on, between the Me Too movement and anime devotees that has raged for months. A group of attorneys critiquing the case through the hashtag #LawTwitter hashtag also has been sucked into the controversy. Oh no, make no mistake, LawTwitter is doing all of the sucking on their own. That's entirely, believe me, they are all too happy to sit there and suck. They have been sucked into nothing. They've been sucking off a lot. Nova Zero says Lemoine lies to the court and steals from charity. He's like Toye's weapon of choice, the universal fraud. Rekieta, an opinionated rural lawyer whose YouTube video channel has more than 75,000 subscribers, was among those drawn to the case. In April, with Rekieta's GoFundMe drive financing his legal fight, Mignogna filed suit. Well, we've got a GoFundMe mention. It might have been mentioned earlier, but I think I've kind of missed it. Thank you to Edward Bush. We're now at $258,375. Thank you so much, Edward, for that for the donation. The relationship between Rekieta and the actor is hard to gauge. It's not, though. Mignogna said in a deposition that he didn't know the young Minnesotan before Rekieta launched his fundraising campaign. True. So it's not hard to gauge at all. He also said the GoFundMe drive was entirely Rekieta's idea. That's not quite true, as I've said. This is a minor semantic difference. As I've said, the audience asked me to do it. The audience asked me how they could help Vic and if there was a GoFundMe. The audience did it. It's not entirely my idea. The audience asked me how they could help. But I don't know if Vic is... I don't know if he's 100% clear on that. But he knows it wasn't his idea. I think that's what he was trying to say at the deposition, that it wasn't his idea. It was my idea, which is fine. I mean, but I want to clarify that as much as it was my idea, it was really because fans asked me how to do this, how to get something. And added that it was Rekieta who suggested that Mignogna hire Texas attorney Ty Beard to represent him. Yep, that's true. Relationship between Rekieta and Beard is not so mysterious. It literally is as mysterious as the relationship between me and Vic. According to a codicil supplied by one of the defendant's attorneys, Beard is the executor of Rekieta's grandfather's estate, Louis Walter Owen, who died in 2016, was a wealthy engineering consultant who donated money enough for a Dallas-based Christus Trinity Mother Francis Hospital to build a new heart center. That's also true. Also true. His grandson, Rekieta, is among Owen's beneficiaries. That's not true. Why are so many lawyers bad at reading? The beneficiaries are my grandmother, as long as she is alive. And then, following her death, the trusts that are listed in the document. My grandmother, while she's alive, and then after she passes, the trusts, explicitly named trusts in the document. I am not a beneficiary of the will. All of the funds go to my grandmother, and then she's still alive. And then 3 named trusts, of which I'm not a beneficiary. These are lawyers. And they can't read. Okay. The attorneys, Rekieta, spell it right so people can come watch. YouTube channel bills him as a lawyer who law-splains legal topics to the internet, fueled by whiskey and rage. True. On February 11th, the same day that Mignogna lost his Funimation contract, Rekieta began using the platform to defend Mignogna. I don't know if that's fair, that I was defending him immediately, but I was doing videos on him. His near-daily web show, apparently broadcast from his home, often lasts 2 or 3 hours. As the Texas #MeToo case has played out, Attorney Beard has appeared as a guest several times. Ooh. Rekieta's own online commentary ranges from calm, almost cerebral analysis of both sides' legal strategies to roughhouse attacks on the defense and their attorneys. That's because their attorneys are cucks. Defendants are terrible, terrible people. They're awful. They're liars. They've lied the entire time. We can show it over and over and over again, and they can't erase that from the internet. That they lied to ruin Vic's career. They did it. They did it. They're bad people. Bad people lie about other people to cause them damage. Bad people do that. There's nothing wrong with saying that bad people lie to hurt other people. When are you going to get this through your head? You can win on a technicality all day, but you're bad because you lied to ruin someone's career. and life, and you hoped he died and you know it. You want him to die now. You want him to go away. You never wanted him to defend himself. You never wanted anyone to stand up against you. And everyone who has been abused, has been threatened, has been doxxed. All of them. You're going after everybody who dared say a word about the fact that you lied to ruin Vic's career. And I will not stop calling you bad people for it. You're bad people, and you should feel bad. Anyway, quote me, I think it's fantastic that you have to spend tens of thousands of stupidity dollars to fight this in court. I do. He said at one point, directly addressing respondent Toye, if you would have settled, I would have been done talking about this case a long time ago, you idiot. True facts. True facts. Another time, he gave a guest speaker a platform to describe step by step how she systematically doxed a woman who took part in the social media flame war surrounding the case. I did. That was M. That was M. They also attempted to dox M. So, good job. Doxing means digging up and publishing the home address, phone numbers, and even cars owned by people so that others can target them for intimidation and harassment, often in person. Wait, what? That's not what doxing is for, or what doxing is at all. As I have said. Now I have to say it again. Only because someone who is not me has said it. Don't bother any of these people. Don't call them. Don't go to their house. Don't go shake their hand in public. Don't ask them about this case in public. Don't engage with them. Don't talk to them. Don't harass them, hassle them, or bother them in any way. I've said it over and over and over again, and I still get accused of this. Now, here we go. In that April 9th broadcast, Rekieta never suggested his audience should follow suit. Thank you for at least that much. But he does suggest that doxing is easier than most people think. True. And that it's almost inevitable for anyone who engages in social media debate. True. Quote, it's something that people need to consider when you're going to talk online about something. True. The lawyer said, someone eventually is going to look for you. It's a numbers game. True. True facts. Real talk. Real stories. Real people. If you talk online, the odds are eventually someone's going to be mad about it and try to dox you. They're doing it to me constantly. Okay. Rekieta did not return multiple phone Monday calls. I don't know what phone Monday calls are. What was this? What was this? October 3rd, he wrote this. Would have been... Was I in Hawaii or flying back? October 3rd. Monday, September 30th. Oh no. Wait a minute. Where was I? I'm trying to remember what I was doing that day. September 30th. This is too innocuous. Hold on, let me check my other calendar. Calendar. December 30th. Oh, yep, I'm in Hawaii. I was in Hawaii. Okay. Seeking comment for this piece. Escalation Sean Lemoine. I don't know who Escalation Sean Lemoine is. Sounds way more interesting than actual Sean Lemoine. An attorney who represents Rial and Toye in the suit said the open warfare between the hashtag MeToo and anime communities predates Rekieta's arrival to the conflict. Then it's not my fault. Lemoine saying it's not my fault. He said the whole thing was my fault. But the abuse that people have dished out has increased exponentially since Rekieta started using his YouTube channel to agitate for the actor, Lemoine said. Even Tarrant County State District Judge John Chupp was targeted. Police forwarded to Chupp an email, which he revealed in court on September 17th. It called the judge a brain-dead moron and expressed hope that someone accuses him of rape. Well, when people started uprising, the email said, I hope your court is the first thing targeted. At one point in the litigation, Lemoine filed an anti-slap motion seeking to depose Rekieta in this case. They accused me of bad legal analysis. I'm sorry, Kevin. This is not what happened at all. That's not what happened. A strategic lawsuit against public participation case is a nuisance suit, often filed by people of means to silence other with less wealth, Lemoine said. Lemoine said he wanted Rekieta to explain his motives for financing Mignogna's defense. I don't like that your clients lied to get someone canceled. It's a theme. I'm opposed to the cancel culture that you love. And the only thing saving you, Lemoine, is no one would believe you tried to sexually assault anybody. Because they don't think you can. Felipe Mouve says, I'm too far away for the creeps to reach me anyway, but I'm really tired of receiving punches from the unethical morons. Me too. Okay. That might help the court determine whether the case was a mere harassment suit, Lemoine said. However, Chupp never ordered Rekieta deposed. Lemoine never pursued it. He got an answer nonetheless. On July 9th, after the motion was filed, a furious Rekieta took to YouTube to explain his involvement and ridiculed Lemoine for not already knowing the answer. There are hundreds of hours of video on my motives for contribution to the GoFundMe war chest, Rekieta said. The biggest one is that I just don't like any of the defendants. I think they're terrible people and I want to see them ground into dust. They are. They're terrible, terrible people. People who lie to harm others are terrible people. The amount... You know what I could have said about these people this entire time? All the, like, half-truths that have been sent to me, the rumors, the speculation. If I had spent any amount of time going through it, I could have said some of the worst stuff in the world about them. But I couldn't verify it. You know what I could verify? That Monica got Todd thrown off a panel at a ZoomiCon. It was her. She did it. She lied about it in public. In public, she lied about it. But I know she did it. I can prove it. I know that they lied about KamehaCon. I know they actively tried to get Vic kicked out of KamehaCon. I could prove it. I could prove that. I can prove that Monica lied about her encounter with Vic. Because she has 3 different stories. And the main witness, the only witness that she says would have noticed, said, nope. I can prove that too. I can prove all sorts of things. And all those things have been said. If I had done an ounce of the lying that you terrible people have done, you'd somehow look even worse. But then it might come out that I was lying, so I didn't do that. Because I don't lie about people. You do! Corthus says, Lemoine tried to sexually assault the mosquito. That's how he got West Nile. Etro Lobo Republic 1 says, first super chat ever. Hey, thank you. Namco announced early this year that Broly from the new movie would be included in Dragon Ball FighterZ. You hear from your sources if they replace Vic's voice. I'm pretty sure that's not his voice. Suspect it's the last bit of content as well. Yeah, I would not... I mean, guys, I don't think there was a chance that at the beginning that Funimation would settle and agree to bring Vic back. That clearly seems to have gone out the window. I think everybody and Vic needs to resolve the fact that Vic's not going back to Funimation or Rooster Teeth. That's just never going to happen. That if you want to see Vic involved in anime, manga, voiceover type stuff, you're going to have to urge a different studio to hire him, or you're going to have to support him in some independent endeavor to do so. I have an idea of what would be great for Vic to do, in my opinion, but I'm not his guy, you know? Like, I'm just a person. I'm not his business partner. So, you know, I think there's lots of potential for him. I think there's clearly a group of people who want to see him work. Now we have a way to get past the gatekeepers, right? For all of its flaws, Comicsgate has shown us that. And by its flaws, I mean the infighting and the downward spiral and the weird pettiness that's erupted amongst Comicsgate. For all of those flaws, ignore those. They've shown us that we have the ability to undo the gatekeeping of companies like Funimation. We have the ability to distribute products to people. But anyway, okay. Let me restate. They are terrible people. Terrible. People who lie to end other people's careers and lives are terrible people. Objectively. Objectively bad. So there you go. In a brief September 17th hearing, Chupp ordered the two sides into mediation. The only thing that will quell the open warfare, he said, is for the two sides to agree on a resolution. That's because Chupp's an idiot. That wasn't going to heal the anime community. That's a judge putting on a cape instead of a robe and not realizing that when you're wearing a cape instead of a robe, your penis is hanging out the front. Chupp is not the superhero to save anime. And forcing them into mediation and even having a mediated settlement was not going to save the anime community and heal the rift. You have a group of people and a company who have gotten together, obviously, and lied about a person to ruin them. Or at their most charitable, they have decided a decade after events to bring up said events as evidence to ruin someone. A decade later, a decade of not caring has gone by the victims, by the companies, by everyone they know. Everybody they know knows about this stuff because it's all obvious. According to their own words, everyone knew. This is the most charitable, is that according to their own words, everybody knew all of this was going on for a decade and all ignored it until now, and then got together at the same time and decided to throw Vic out. And again, being the most charitable, they only did it because of a Twitter brigade. That's it. Otherwise, without Han Leia, according to their argument, without Han Leia, Monica Rial, Jamie Marchi, Kara Edwards, Michelle Specht would have shut their stupid lying mouths. They would have just kept their mouths shut and let people continue to be victims. Without the tweet from Han Leia, they would have all been fine with it. That's the caliber of person that we have. Remember how I said they're terrible? Know how I know you lying? Because this doesn't match. Either you're terrible people who lied about a man to get him ruined, or you're terrible people who endorsed a serial predator's activity for decades until someone on Twitter made it okay for you all to talk. And don't act like the damsel. There might be one damsel with no power amongst you, maybe, but Monica Rial has touted over and over that she's one of the biggest voices in anime. Funimation is clearly not a helpless, hapless baby in this argument. They're liars or cowards or both. And what they would be doing now, according to them, is if Han Leia didn't tweet something out, they would all be fine with his behavior, and he'd probably be a director at Funimation right now. Think about it. That's what would be happening right now, if not for a tweet. Okay. Svenger McSpazzy says 6 things, even 7 the Lord hates, things he cannot stand, proud-looking eyes, a lying tongue, hands that shed innocent blood, a heart that thinks of wicked things, feet that run to evil, any who love to lie about others. Go. Thank you for that. Okay. If the court imposes a ruling ending the case, he fretted, the fighting and abuse might continue for years. No ethical lapse. So this is supposed to be a subheading right here. Whoops, I've got the redaction on. So this must supposed to be on its own line, a subheading. A number of attorneys following the case on Law Twitter have criticized Rekieta's behavior, some calling it a conflict of interest. Ooh. I wonder if their analysis is going to match up to reality, because they're good lawyers. They know all about it. They're special. Lemoine said he finds the Minnesota attorney's conduct personally offensive. Well, that's because you're personally offensible. And wonders whether he has violated Minnesota rules of professional conduct for attorneys. The short answer, hey Lemoine, 2 Minnesota legal ethics experts indicate is no! Sorry, that was loud. No! Your analysis and Law Twitter's analysis is wrong. Over and over and over again. Even the idiot Minnesota attorney who filed an ethics complaint against me was wrong. Because you're wrong. You can attempt to sit back and mock my legal analysis all day. You can do that. Go ahead. But know that your analysis about my ethical responsibilities is resoundingly proven to be incorrect. Over and over and over again. Let's read on, shall we? Bill Werns of counsel at Dorsey and Whitney and a legal ethics expert, Dorsey and Whitney is a huge firm here in Minnesota, would not comment directly on Rekieta's case, but he did offer that lawyers have great freedom to conduct themselves however they want when not representing a paid client. Rule 8.4 includes a catch-all clause saying that lawyers, quote, shall not engage in conduct that is prejudicial to the administration of justice, but being a public instigator doesn't necessarily violate that rule, Warren said. Quote, disputes with neighbors and nastiness to people, profanity, and all kinds of things that don't seem like Atticus Finch aren't necessarily prejudicial to the administration of justice, he said. Because if they were, all lawyers would be guilty of this all the time. All of them. All of them. Chuck Lundberg, an ethics attorney who served 12 years on the Lawyers Professional Responsibility Board, agrees with his colleague. He said that doxing, in most cases, probably is not illegal. And I haven't done it. Can we just please say that? I haven't doxed anyone. Meanwhile, Lundberg sees nothing obviously amiss with Rekieta helping the executor of his grandfather's estate get work, either on Rekieta's or on Beard's end. Oh, shocker. Shocker. Critically, he said Rekieta has declared that he is not on the actor's legal team, so his YouTube platform, which addresses a topic of clear public interest, falls under his protected First Amendment right to speak his mind. Thank you, Chuck. Let me send you flowers drenched in whiskey or something. Nothing obviously unethical is jumping out at me, Lundberg said in an email Tuesday. Okay. So I'm not going to go through the rest of this. That's the end of the document there. Like I said, we're not going to go through the rest of Lemoine's drivel. Oh my gosh, Sam Johnson's document is less. Or is left, not less. It's left. Whew. I'm running out of steam. I'm running out of steam. Yes, the beer. Fred DB, thank you. I'm gonna go grab the beer. I'm just, gosh, I'm getting tired of this. Now, Johnson's filing is better than Lemoine's, but not much. Not much. Here we go. I'll be right back. So I was just eating some of that strawberry Pop-Tart. I was busy today. I didn't get dinner. You know, whatchamacallit? I squeak the door just so you guys know when I'm coming. For all you people who want me to degenerately oil that door and make it not squeak, then you won't know when I'm coming. I'll sneak up on you. All right. Here is this thing? This is like just a hair. Bring this down just a little bit. Why? Why would it do this? Ugh. Okay, well, it's gonna be like this, I guess. Lovely. This beer's pretty good cold. Again, not a beer fan. The cold numbs that hoppy taste a little bit. I don't, yeah. I'm just not a big, man, I'm not a big fan of beer. Okay. So, defendant Marchi's motion to determine sanctions and attorney's fees. Defendant Jamie Marchi asked this court to determine the amount of sanctions and attorney's fees to which she's entitled pursuant to the Texas Civil Practice and Remedies Code. And in support hereof respectfully shows this case was always a game to plaintiff. First of all, that shirt was created a long way in, so saying it was always a game is silly. Second of all, that case, that shirt has nothing to do with the case. That shirt has everything to do with Law Twitter. But that being said, so this is just citing the YouTube video that this is from. Plaintiff's claims, factual and procedural history. Plaintiff's claims against Marchi were never genuine, never brought in good faith, and never supportable pursuant to any reasonable legal theory under Texas law. Marchi asked the court to take judicial notice of its file, with particular emphasis on Marchi's filings and plaintiff's responsive pleadings thereto, if any. Marchi also incorporates by reference the evidence and arguments made a part of defendant's Monica. Yeah. So everybody else's motion is included in their motion. Okay. Whoops. Plaintiff filed his slap lawsuit against Marchi on or about April 18th. Marchi promptly answered on May 31st after being served with process after dodging service, which she's allowed to do. She's allowed to not make herself easy to be served. It's just kind of funny. On July 19th, 2019, Marchi filed her motion to dismiss pursuant to the TCPA.
After continuing the initial hearing setting on Marchi's TCPA motion and the other defendant's motion to dismiss, the court heard all defendants' motion to dismiss on September 6th, which time the court dismissed all claims against Marchi. On October 5th, the court dismissed all other claims asserted against the remaining defendants in this matter. Wait a minute. Johnson just argued that the whole case is resolved. Evidence in support of motion. In support of this motion relies upon the following competent evidence, all of which is incorporated herein by reference. Letter from Ty Beer to Jamie Marchi, deposition of Vic Mignogna, declaration of Jamie Marchi, tweet by Stan Dollin, examples of Damn It Nick t-shirt, photographs of plaintiff counsel and Nick Rekieta, team photos, and declaration of Samuel H. Johnson. I love how lawyers try to do this. It's like the subtle, oh, if I call it team photos, he'll think Rekieta's on the legal team. Argument and authorities. Sanctions. Defendant asks the court to award sanctions in her favor against plaintiff for not less than $50,000. Because the court ordered dismissal of plaintiff's legal action against Marchi, the court is required to award Marchi sanctions for having to defend against plaintiff's illegitimate legal action. The Texas legislature mandated sanctions under the TCPA in an amount, quote, sufficient to deter the party who brought the legal action from bringing similar actions. There's little jurisprudence directly on point to offer the court guidance as to what factors should be considered in achieving the purpose of the TCPA. However, the 14th District Court of Appeals in Houston recently examined a broad set of considerations. Understanding that the court is well aware of the factual and procedural history, I wouldn't say that Chupp is well aware of the factual or legal or procedural history leading to this point. I'm not prepared to say that Chupp is well aware of anything. Marchi has compressed such considerations for brevity and judicial economy. Plaintiff claims were always fraught with frivolity and bad faith. Bad faith. She lied about me, caused me damage. That's the baddest of faith. Felipe Mouve says, Nick, the GoFundMe is a victory in itself. As you said, we need to get at least $500,000. They see it as Vic's lifeline. From the very first substantive communique sent by plaintiff, it was clear he knew he had no basis in law or fact to assert claims against Marchi. As stated in Marchi's TCPA motion, 3 of the 4 complaintive tweets didn't even reference plaintiff, and plaintiff's lawyers failed to muster a colorable argument, even outside the bounds of the Texas Rules of Civil Procedure. Though some of Marchi's tweets could be argued to contain strongly worded hyperbole, they always fell short of fitting into even the most liberal construction of the defamation claim. Except the judge disagreed with you. In court, he said, but wouldn't, pulling versus touching hair, making a sexual comment, all of those things, wouldn't those be fact matters? And you said yes. So this isn't true. Indeed, Marchi's name only appears substantively 8 times in all of plaintiff's 14-page original petition, 9 times in plaintiff's 14-page amended petition. Only one of the tweets from plaintiff's takedown letter even appears in any iteration of plaintiff's petitions. It is not the tweet that actually references plaintiff. After having filed his dubious claims and presumably prepared for testimony with his attorney, plaintiff could still not point to the nature of the defamatory claims upon which he brought suit. Only one tweet referenced plaintiff by name or alleged any act by him, and in his own deposition, plaintiff admitted Marchi's allegations were true. He did not. He did not admit they were true. This is a disingenuous nature of Sam Johnson, which is frustrating because he didn't admit to them at all. Let's see. Leaving us all to wonder even more why Marchi was ever in this lawsuit in the first place. If any question remained as the fact that plaintiff neither had nor desired a genuine legal dispute with Marchi, that question was answered with resounding silence when he finally filed his response to Marchi's TCPA motion. As pointed out in her reply thereto, in all of his 1,888-page response, plaintiff did not cite a single piece of credible evidence relating to Marchi. More specifically, except her tweets. 45 days after Marchi filed her TCPA motion and 5 months after plaintiff filed his original petition, plaintiff was unable to and did not even attempt to file a single shred of evidence pointing to Marchi or her alleged misdeeds. Why? Because this lawsuit was never about justice or equality, only about grinding Marchi into dust. Which is interesting because, again, this quote is drawn from plaintiff's and plaintiff's counsel's friend, an alleged Minnesota attorney, Nick Rekieta, on his YouTube channel. So it's not attributable to plaintiff or plaintiff's counsel. Only me. We see the problems here. I hope they run roughshod over that. that all of their basis for sanctions are someone that the plaintiff is not affiliated with and has no control over. Defendants incurred out-of-pocket expenses in defending against plaintiff claims are reasonable and necessary. Defendant has endured extreme and unwarranted distress and prejudice as a result of plaintiffs and his comrades' hate-mongering. What has Vic done? What did Vic do to Jamie Marchi? That's interesting. The impact on Marchi's life wrought by plaintiffs and his followers' actions is somewhat difficult to state with any measure of objectivity because it's a lie. From threats against defendant's life to indirect threats against her fiance's children to a noticeable reduction in her recording and convention work. Oh, that's just a shame, isn't it? Oh, man. Defendant anticipates that the consequences will continue to permeate her life for years to come. So hard when you lie about something and then someone points it out. Oh my God. Defendant has been doxxed by various of plaintiff's minions, most notably on the Kiwi Farms website, who is also doxxed plaintiff, by the way. The plaintiff has been doxxed on Kiwi Farms, and suggesting that Kiwi Farms is a minion of the plaintiff is an obvious fraud upon the court. Obvious. Wow. Wow. Nya says, belated, but them trying to ruin a couple people's careers is vastly more charitable than them telling the truth after letting hundreds of underage girls be molested, both for the same motive of keeping cushy in their career. Yeah. I don't think the hundreds of underage girls were molested by Vic, though. Okay, let's see. Which plaintiff's counsel has come to rely on as an additional, if illicit, research arm of his law firm. No, they're making public statements. They're making public statements, public posts that are viewable by anybody. And anybody can go find them. I don't know that Kiwi Farms is cited in the plaintiff's documents. So that's interesting. Let's see what this footnote says. Oh, it's just in Marchi's declaration, where she just makes it up. Oh, perfect. Meaning that information about her family, home, and other details have been compiled as a means of getting plaintiff's followers information with which to harass her. No. Sweetie. Pumpkin. Round as a pumpkin. Sugar cheeks. Goblin King. Kiwi Farms does not post information for the plaintiff. They post the information for everybody. They just post the information. That's the nature of Kiwi Farms. How you don't understand this is a little bit sad. As soon as plaintiff commenced his lawsuit, several conventions declined to keep defendant on as a guest. Oh, God, that makes me sad. Defendant has endured threats and interruptions at conventions that she has attended. That actually makes me sad. I don't think people should do this. I don't like it. And I've never brought one of those people on, by the way. I've never brought one of those people on. I've always said that they shouldn't do that. And I haven't given them attention. Right? Like that's... No, I get no respect. No respect. Whew. Even after filing her methodical TCPA motion, having it granted as to all counts against her, defendant has continued to receive death threats. From who? Who? Are you going to cite that piece of paper? That fake piece of paper that could have been written by literally anyone? How do we know you got it? Did it come in the mail? Or did you just draft that up by hand? Plaintiff and plaintiff's counsel almost certainly bear joint culpability. Ooh, tie. Defendant does not likely make this assertion. Defendant's counsel has never before felt that such a unity between the acts of a party and a party's counsel warrant such a statement. Under these circumstances, however, it is nearly impossible to separate them. And immediately we're going to go to where? To tie? No. As the court is already aware, an alleged Minnesota attorney named Nick Rekieta started a GoFundMe. Whoop, whoop, whoop. GoFundMe alert. We're at $258,600 with a big contribution from Felipe M. Thank you, Felipe. John Hogan, Donald Svitak, Trevor Wright, Edward Bush. And then the anonymous ones. Anonymous. Did I read some of these earlier? I may have. Yeah, I read Edward's earlier. So thank you guys for your contributions. Again, there will likely be more references to the GoFundMe as we go on. Started a GoFundMe page for the express purpose of funding plaintiff's crusade against his victims. She's not a victim, bro. She's not a victim of anything. That's the sad part of this. The sadder part is that Jamie Marchi is apparently now receiving funding from a legal defense fund for victims. Yet she's not a victim. Jamie Marchi is stealing money from women who have actually been sexually assaulted. Think about that. Jamie Marchi is taking money that is supposed to go to women who have actually been sexually assaulted. That's how far she's willing to go for the lie. That's how far Jamie Marchi, the liar, is taking the lie. She's even said that she's not that much of a victim compared to other people. That's her words in her tweet that Sam is pretending doesn't exist. She said she's not really that much of a victim compared to other people. And here she is. She's taking money from women who have actually been assaulted. Mind-blowing. The greed, the disingenuous nature, and the disgust of these people. When I say they're terrible people, they're terrible people. Absolutely awful human beings. Interestingly, though, the GoFundMe page identifies plaintiff's counsel, not plaintiff, as a beneficiary to the funds raised. Whoop, whoop, whoop. We've got it. Let's point it out. Let's educate you, Sam. Let's educate you, you liar. You know why it indicates Beard Harris? Because as I have explained, and as you would know if you asked GoFundMe, they indicate the beneficiary of the person receiving, or the place or entity receiving the funds. They did that. When I established it, you liar, I set it up for the benefit of Vic, and it was on behalf of Vic Mignogna. That's how it was when I established it. But when we directed the money to the IOLTA account, GoFundMe changed the beneficiary to Beard Harris. I can't do anything about that, and that's how they protect themselves from fraud. Fraud from people like you, who are apparently content to lie to the court or misrepresent the facts if we're being charitable. That's not my choice. That's how GoFundMe does it, and I have explained it. It's written in there that the funds go to, let's see. Oh my. October, let's see. Here we go. February 25th, 2019. Hey, Sam, maybe learn to read. You may have noticed a change to the beneficiary on the page, and I want to update everyone on what this is and what this means. We have linked up the GoFundMe account to the law firm's IOLTA account. An IOLTA is a trust required by Texas law and laws of several other states, and the acronym stands for Interest on Lawyers' Trust Accounts. These accounts are designed to hold money temporarily on behalf of clients and are accounted for separately from the law firm's funds. Any interest earned by these accounts actually gets forwarded to the state to fund legal aid programs. The beneficiary shift indicates that the senior partner of the law firm, Ty Beard, who is the named party on the IOLTA trust account, The firm is Beard Harris Bullock Hughes. With this transition, the money will be moved into the IOLTA account, and billing will be done against this amount. Again, any remainder will be donated to the Salvation Army shelter stated in a previous update. Please understand that the GoFundMe will remain open. You can continue your support. We still do not know the full scope of the process, which largely depends on the actions of any opposing parties. Thank you all for your continued support of Vic, and I look forward to updating you as more information becomes public. It's almost like it's not a mystery at all, Sam. Why you lying? Why you lying? Okay. Though plaintiff testified in his deposition that he and Mr. Rekieta have little to no connection, true, it appears from individuals such as Stan Dollin, who purportedly provided testimony for plaintiff's response to defendant's TCPA motions, that plaintiff and Mr. Rekieta are indeed quite close, recently vacationing together in Hawaii. Why are you lying? I didn't vacation with him at all. We both happened to be at the same convention for work, our respective jobs. Sometimes run parallel. And it's interesting because in February, I didn't know Vic. By September, I know him a lot better. And I have met him at Matsuri. And I did meet him in Hawaii. And I also saw him at Bubba Fest. And I got to talk to him. I talked to him, Sam. Big conspiracy. Chaos Recon 137. Hey, Nick, first super chat. Hey, Chaos Recon, thank you. I wanted to be a voice actor, but people like Monica and the rest of the fraudulent voice actors that wish to ruin an individual's career over hearsay make me glad I'm not a voice actor right now. You shouldn't, I mean, I'm going to say this tongue-in-cheek. You shouldn't want to be a voice actor because they're absolutely pitiful, pitiful pay. They're operated as if they're slave labor. It's disgusting. Really, really terrible. Funimation is awful. Funimation located itself in Texas to not pay union rates. And Funimation just absolutely pillages the talents of its voice actors with almost no pay and very little support at all. So good job, Funimation. Plaintiff's counsel has also appeared on numerous times on Mr. Rekieta's programs on YouTube, even sponsoring and wearing a shirt mocking this court's proceedings. Nope, not true. Not true. Plaintiff's counsel has further published and admired photographs and additional fan art depicting himself, plaintiff, and Mr. Rekieta as a team. A fan drew us as a team. That means we're a team, y'all. You want to know the art? I have it. Do you guys know how I'm Vic's lawyer? I'm Vic's lawyer because this. There you go. Retainer agreements? What's that? What's a retainer? What's a representation agreement? What is all that? Nope. Nope, it's this. It's a metal printed art piece. See, you know how I became his attorney. You can tell because Ty and I are in power armor from Warhammer 40K. That's actually how you sign on to someone being your attorney. You draw them in power armor. That's what makes it. And you give us iron halos that are on fire. Oh, also you have the Octet path. That's further evidence. That's further evidence that I am Vic's attorney. Now I'm on the team. It's embarrassing. Embarrassing levels of conclusions here. And just so you know, that's citation 21. That's the citation they've got. Team photos. That's not a photo, by the way. That's a drawing. Simon does drill rings. An appropriate sanction will necessarily account for the $250,000 war chest from which plaintiff has benefited. As stated above, plaintiff has a GoFundMe war chest. Boop, boop, boop. Here we are. We are at $258,665, with additions from Natalie Brathwaite and Brandon Weal. Thank you guys so much for contributing. I have a feeling there's going to be more mentions of the GoFundMe in this document. I don't know. I have a hunch that they can't get it out of their heads. They can't understand why people would stand up and say, yeah, those lying ladies can't do this. They can't ruin someone like this. Started, managed, and presumably spent for him, allowing plaintiff and his counsel to wreak havoc on plaintiff's victims' lives at almost no cost or expense to anyone other than the victims themselves. As of the filing of this motion, the GoFundMe page, oh my gosh, I don't have time to bring it up every 2 seconds, Sam. Slow your roll. Beat down that boner. Stop talking about it. There it is again. Has raised almost $260,000. Plaintiff testified in his deposition both that he had not paid his own lawyers for bringing this suit on his behalf and that he anticipated filing additional lawsuits. That's not true. That's not true. Actually, he did testify to paying the previous attorney that he hired. So, you know, there's that. I believe he testified to that. He talked about hiring them. I assume he paid them. Let's see. And that he anticipated filing additional lawsuits. Indeed, so that's his deposition. Of course, that line is taken out of context that he may file lawsuits against other people who have destroyed his reputation. May. Indeed, plaintiff has also testified under oath that he's earned $161,000 this year in convention appearances revenue alone. If the sanction is intended to deter plaintiff and others like him from bringing their malcontent and bully tactics into Texas court, what malcontent and bully tactics has Vic done? Vic hasn't done any of it, Sam. Not a thing. Not a thing. Everything you're accusing him of was done by me. This court must account for and work around the extensive financial cushion already surrounding him. They want him broke. Notice what that was, right? The extensive financial cushion. They don't want him to feel the hurt. And by the way, having people give you $250,000 that you then have to give to someone else, that you have to pay to something, like, oh, your fans support you this much. Here's a whole bunch of money of support, and then you have to give that to someone else. If you think that doesn't sting, you don't feel that, then you're an idiot. Because I'm sure Vic would much rather take $250,000 and do literally anything with it. Literally anything at all. Other than file a lawsuit to try and save his career. And file a lawsuit that means that he can show that these people lied about him being a pedophile rapist. But they want to get around that financial cushion. They want him buried. They want him punished. They've always wanted him punished. Arguments and authorities on attorney's fees. Defendant asked the court to award her reasonable attorney's fees in the amount of $48,137.50. Costing amount of $354.01. Don't ask why Sean Lemoine's fees were 5 times higher than this. Over 5 times higher than this. That was just... Sam Johnson inarguably conducted the best defense of any of his of any of the clients. Inarguably, he did the best job of any of them. He did it at 1/5 the price of Lemoine and under 1/3 the price of Volney. That's amazing. It's amazing that the other parties are trying to charge that much because they were running up the bill. Court is also required to award Marchi her costs and reasonable fees in defending against this legal action. The only requirement for this court's determination is that the attorney's fees awarded to Marchi must be reasonable. Defendant retained Sam Johnson, the law firm Johnson Sparks PLLC, to aid her in the defense against plaintiff's claims in this legal action. Pursuant to her engagement letter with JNS, defendant agreed to pay JNS a very reasonable hourly rate of $250 per hour for attorney time, $125 per hour for paralegal time. These rates were agreed to after negotiation between defendant and JNS. Defendant stated she could not afford to pay JNS's standard hourly rate of $350 for attorneys and $150 for paralegals for protracted years-long litigation. In order to incentivize JNS to push the prompt dismissal in recognition of the benefit to the defendant of such, defendant agreed to pay a bonus rate of $100 per hour billed if they were able to obtain dismissal of all claims within 6 months of the engagement letter or by October 26, 2019. Through filing this motion, defendant has incurred 135 attorney hours and 7.1 paralegal hours of billable time. Worth noting is that JNS has also written off for no charge 7.7 attorney hours and 2.8 paralegal hours, for which defendant does not seek an award at this time. Thus, defendant has incurred actual charges of $47,250 in attorney hours and $88,750 in paralegal hours. Defendant took extra care to minimize the cost and expense of defending this action. 31. So we've got Johnson's declaration. A review of the court's file shows that many of the filings were submitted by defendant's co-defendants and or plaintiff. Defendant did not call for any of the discovery conducted in this matter, and in fact did not incur additional fees to mandate plaintiff's responses to her own written discovery requests, but were stayed pursuant to the Texas Civil Practice and Remedies Code upon filing the first TCPA motion to dismiss. Nevertheless, so they were stayed. So so that's she didn't try to get them after they were stayed. Okay. Nevertheless, the ambiguity of plaintiff's claims, the public nature of the claims and participants in the lawsuit, and the technical nature of the TCPA necessitated particular time and care in defendant's approach to these proceedings. Defendant also asked the court to award her contingent attorney's fees in the amount of $37,500 in the event of appeal to Court of Appeals and a further $45,000 in the event of an appeal to the Texas Supreme Court. TCPA was specifically designed to prevent and punish lawsuits of the type plaintiff brought against defendant. Circumstances like these where a plaintiff has imposed so much burden with none on himself. His career was destroyed by your lying client. That's the burden. His career, his reputation, all of it. All of it was destroyed by your client. The only reason he has anything is because he stood up to fight back. You can't have that. Can't have that, can you? Nova Zero says, this is why I have to walk away from you. I stand with Vic Degenerates. Your buy-in is a mechanical death machine, and taking a picture with Vic, you ruin it by not murdering these licentious traitors. What would the God Emperor think? Oh my gosh. Let's see. So much of a burden done on himself. It is incumbent upon the court to ensure that he and others similarly situated understand there will be consequences for attempting to stifle free speech. Literally what you people have been doing the entire time, Sam. To me. And what your lovely client is trying to do to me now. And will continue to do. Will continue to do with her media campaign, I'm sure. I'm sure that if this case were dropped tomorrow, I'm sure they'd quit mentioning GoFundMe, Vic, me, all of that. We are failing to recognize as we all have free speech too. Despite the lack of a good faith claim or evidence to support it, plaintiff saw fit to bring defendant into this case for the sake of silencing her. Nope. Restoring reputation, which is valid. We who have worked on this case have seen it all along. And the court saw it when presented with defendant's TCPA motion and plaintiff's response thereto. Except for attending his own deposition, plaintiff is not engaged in pursuing or proving his claims with any sense of urgency. He can't do anything urgently. You guys control the TCPA filing. He motioned for discovery. He conducted depositions. You guys filed TCPAs which stayed his ability to urgently pursue legal action. What the hell? Law is defined as, quote, as the, quote, regime that orders human activities and relations through the systematic application of the force of politically organized society. Let this case, through the necessary awards of sanction fees, be a reminder to plaintiff that those activities and relations must remain civil and in good faith at all times. Oh, the irony! I would hammer home on this disingenuous argument with, screenshots of Jamie's tweets saying that trash hath been taken out, all of that stuff, her flaunting Her flaunting of her own doorstep, making fun of the fact that they hadn't served her, all of that stuff. Yeah. Yeah, civil and in good faith. Definitely a high characteristic of Jamie Marchi. Including when brought before our judiciary. Yeah. Jamie Marchi knows all about civil and good faith. Literally says the opposite. Wished an underage person had been raped. Do we remember that? Jamie Marchi wished an underage person had been sexually assaulted. All right. This is the letter. This is the deposition. What I want to do is get to just a couple things, and then we're going to be done. Declaration of Marchi. My name is Jamie Marchi. I'm an adult over the age of 18 years. I'm physically and mentally competent to testify to the matters set forth in this declaration. I have endured harassment as a result of speaking out in February 2019 about my experiences with plaintiff. People online have mocked my vocal talent, my appearance, fatso, my family, and my experiences. I have also been doxxed, meaning that a vast amount of public records about me have been compiled. Public records have been compiled to allow for those threatening me. No one has threatened you. To have easy access to my personal information and that of my family. Many of my friends and colleagues who are publicly supportive and or worked with me have also been doxxed in retaliation. It's not in retaliation, sweetie. Kiwi Farms just doxes everybody involved. I have had my life threatened both before and since engaging in this litigation, including after having the claims against me dismissed. True and correct copies of 2 such threats are attached here to as Exhibit C1, incorporated here by reference. I've also suffered a reduction in jobs for which I've been hired. South Carolina Comic-Con canceled my contract in March 2019 because they were overwhelmed with messages demanding they do so. Oh, how does that feel? Wow, that must have sucked. When I announce I'm attending a particular convention, that convention will receive messages that harass them for booking me. Oh, man. God, that must be terrible for you. Holy goodness. And believe me, I don't support this, but I do find it freaking hilarious that you're whining about what you literally did to someone else. Currently, I have only 6 conventions booked for 2020. By November, I typically have about 10 to 12 conventions booked for the following year. Many conventions are hesitant to schedule me to appear because the convention its participants may have to deal with threats and or harassment. Oh, man. That must be terrible. Hey, I'll invite you to BoomerCon, Jamie. You're getting canceled other places. You qualify. You want to come? I'll pay you and all that stuff. When I was attending the Anime North convention in Toronto, an individual aggressively harassed me until he was escorted out of the convention. He returned the following day with more harassment and threats. Didn't you call him like a... You made fun of him quite a bit. Didn't you call him an incel or something? The convention was forced to call the police after he threatened the convention attendees with saying we should not think that he doesn't have firepower. He's in Canada. He doesn't. Because of the constant flow of harassment and threats online and in person thus far, I do not expect they will go away anytime soon. In fact, I fear as soon as this document becomes public, I'll be harassed for the information contained within. Oh, that's too bad. But you're going to news publications and making this more of a thing, Jamie. Why? Because you lying. In May, I hired Samuel H. Johnson in the law firm Johnson Sparks. Negotiated a reduced fee. This is boring. That was it? Here's the death threat. Here's the death threat written on notebook paper to Jamie Cucci, which is not Jamie Marchi. And there is a Jamie Cucci online. Who are they threatening here? Enjoy your victory while you can. This is quoting the thing before this is taken out of context. I'm reading the letter. Enjoy your victory while you can. We know where you live and we won't forget your lies. Hope you believe in the scribbled out Second Amendment. You're going to need it after your part in the witch hunt. Karma is a B word. We do not forgive. We do not forget. This is unacceptable, by the way. This is not acceptable behavior. I believe this 0. Like, I believe this 0%, but if this is genuine, this is unacceptable. Unacceptable. Her info is there unredacted? What? Where? Oh, yeah, it is. Oh, well, too bad. I can't undo it now. Let's see. You're going to need it after your part in the witch hunt. Oh, wait, we read that. So here's this next one. Had a nice phone call from a friend. He sent me this. Enjoy your time on the Big Island, gentlemen. Stan Dolan. Important to note, I did not send Stan Dolan this picture. I did not have a phone call with Stan and send him the picture. I believe that must have been Vic. I don't know if that's true or not. But I did not send this picture to Stan. Either way, yep, that's me and Vic outside of the hotel where we were at a convention. Where I was working, by the way, and I wasn't invited to HawaiiCon by Vic. I was invited to HawaiiCon by one of the faculty or staff or whatever you call them of HawaiiCon. That's who brought me as a media personality. I have gone to 4 conventions as a media personality. This is not out of the norm. And it actually wasn't because Vic was there that I was brought either. So, yeah. Sorry. Not true. So there you go. What else? Oh, my daughters made these. So the daughters of Ty Beard are apparently not allowed to make a shirt in levity about what's going on Law Twitter. That apparently is reflective of the case itself. Obviously, a ridiculous argument. And then here, I told you, the team photos. Here it is. And then Ty posting this picture from, gosh, this chick still looks mad. Anime Matsuri, where again, we were all there. I was a guest of Anime Matsuri. I hosted a panel in which Ty was present on that panel as well. Vic was not a part of the panel. I believe Ty also may have other existing relationship with Anime Matsuri, or maybe he had. I don't know if they still do or anything like that. But the idea, again, that this somehow shows anything other than, well, this is Vic with his attorney, and then here's this guy. We're all in the same place enjoying a cigar. A legal cigar, by the way. Then this is declaration of Sam Johnson about his hourly rate. Johnson and Sparks. And then there's a bunch of, stuff. I'm not going to go through it. Of course, they all requested the mediation fees, even though those mediation fees were supposed to be borne by the parties themselves. It's all ridiculous. I'm done with these documents. Like I said, my analysis remains the same. Even though I assume Ty and company will contest the fees that they have listed on the basis that many of them are inapplicable, I think Chupp will just go ahead and award them fees. I don't think he's going to take a careful look at them. I don't think he's really wanting to entertain arguments about the fees. I think he'll do it. Let's do one more look at the GoFundMe before we go. Here we go. And there we go. $258,975. Thank you for the big donation from Paul Godin. Thank you from Kelly Miller and Anonymous as well. Thank you, guys. We're really close to that 259, and then it's just a step on to 260, and inexorably trudging towards that $300,000 goal. If you're not able to donate, please consider sharing it again, even if you've shared it already. Unfortunately, one of the biggest sharing things that was out there was my Twitter account, which was responsible for lots of traffic to the GoFundMe, lots of exposure when I would tweet about it and pin the tweet, but it is no longer there. So not much I can do about that. But if you guys do would consider resharing it, that would be great. But you've already done so much. Like, I don't want to belittle. 11,000 shares is amazing. And of course, the dollar amount is absolutely huge. So thank you all for doing that, of course. All right. Let's, Felipe Mouve says, so apparently 5-year-olds are writing letters to threaten whales. They were so lazy they couldn't start again when they made a mistake. Yeah, I know. It's kind of just bad form. Just bad form. Refresh. Is there another one? It takes a little bit to refresh it. I'll pull it up right at the end after we go through super chats. But I do think Chupp is going to just go ahead and greenlight all of the requests as stated. I think he'll probably award the 25,000 sanction to Funimation because that's what they asked for. I don't know what he's going to award to Lemoine and Johnson. Really awarding more than about 25 to 50,000 each would be a massive would really be a massive fee that he'd be awarding. And I'm not quite sure he's going to do that, especially considering they're asking for, approximately $500,000 in attorney's fees in addition to the sanctions. So we'll see. But like I said, I do think he's going to award them what they ask for in attorney's fees because the appeals court's going to look at all of it de novo, including the fees. They'll look at all of it. So, yeah. So that being said, let's go through the super chats and justice chats. And then I'm going to do Twitch tonight. I got to grab some food. I'm dying. I'm so hungry. I didn't really have any dinner because I was busy. I got to grab some food, but I will be on Twitch. Probably just strolling through some Inquisitor Martyr again. Maybe doing another campaign or whatever. A campaign of hatred, and violence against the ugly Xenos. Or probably be doing that. But yeah, if you want to come check me out on Twitch, I did just receive partner status the other day, and I'll be looking to expand the content on the Twitch channel very, very near future. I was talking with Lady Rackets about it today, so look for announcements on that coming up. Don't forget Thursday, my man Q, we're talking about a shooting in Florida and the pitfalls of conceal and carry and self-defense and how you avoid them. And then on Friday, we've got Phil from the Dollhouse. He's a manufacturer of sex dolls. On Wednesday, today, there will be no show. Because I will be on the Dick Masterson bonus content dictation. I believe it's bonus content. And I will be helping him do dictation of his Dr. Phil tapes, which were recently recovered. So if you are a Patreon of Dick Masterson, be sure to check it out. Oh my goodness. But because of that, I will not be streaming on YouTube tomorrow. I may do a late Twitch stream. Depends on how long the Dick Show stuff goes. So that being said, let's do these justice chats. And to the person who's just said that this audience will love sex dolls, funny thing is, you won't. Based on that profile picture, you sure aren't going to love the sex dolls. New York Gamers Federation. Catching what we can of the stream. Can't stay up much longer. Work in the morning, but just popping in to say enjoy your parcel. Oh, New York Gamers Federation. They're the ones who provided the beer. This is the most of a beer I've drank in a long time. Praying for wisdom and success on Ty's team. Would pray for Lemoine, but that wouldn't make for good YouTube content. No, you can. You can pray for him too. I guess. Let's see. Pro Hero All Might says, wow, this article is very insulting. You aren't a soldier in Weeb Wars, Nick. If anything, you are a colonel. Oh, thank you. Thank you. And on to the super chats. Let's see. Bad Vibe says NPR did Vic's story in the last week. Marchi's statement, and you're included with audio from a live stream. Info in email. Hey, thanks. Thanks, Bad Vibes. I have seen it. I haven't listened to the audio. I'm not really interested in how NPR is going to change the meaning of that story based on what Jamie Marchi is there weeping in front of them saying, I don't really care. Sergeant F. Off says, dump Chupp. We need a new judge. Robert H. says, thoughts on Project Veritas leaking ABC News audio about Epstein's story being buried years ago. Good. Go for it, Project Veritas. They're great. Twitch ID. Boy, George, my Twitch ID is in the description, but it's twitch.tv/f/Rekieta Law. Comicsgate Live says it's okay to be Jewish. It is. It's okay to be Jewish. Talbot Link says, finally, Phil is good people. I can't wait to talk to Phil. I really can't. I'm intrigued by this whole development of this industry and what it means. What it means as these things get more and more advanced and what that's going to do to the relationships between men and women. I have no idea. I know what Drexel thinks. Drexel thinks women are done. Once robots get to a certain point, once the sex dolls get to a certain level, that women are gone forever. And maybe he's right. I don't know. Bakken Kiwi says, fashionably early and incredibly heterosexual. Have some shekels. Hey, thank you. Thank you. Gravy Donson says, fellas, I come to you in a time of great need. I recently lost a subscriber, bringing me to 31. If one of you could sub, that'd be really nice. So Gravy Donson is looking for one subscriber. Thank you, Gravy, for that chat. Andrew War Snowboard says, con sluts cannot silence the cement truck. Darian Morris says, hey, I sent you an email earlier asking for your take on a personal legal matter. Thought I'd sent you a super to let you know about it, Boomer. I think I saw your email, and if I'm right, I'm trying to procure a referral for you. No one important says, why do they keep doing this? They keep doing this from day one. People, Nick does not equal Vic. Get that through your heads. You guys are such babies. Mario Carter 13 says, I don't want to dox anyone. Doxes the brewery. Demon Ralph says, free super chat. Why not? Sure, why not? I'll use it to say, I love you, Nick. Blessing for all you do, bro. Hey, thanks, Demon Ralph. Sir Garforth says, could you please explain your relationship to Andy Worski? Relatively new to your channel, and I know he went kind of crazy and was just curious. Sure. Andy Worski came on my show in the middle of the Tonka situation. I had him on. I had just Andy on for a little bit during some thing where, someone had swatted him or something. They'd lied or doctored pictures. I can't really remember. But I had Andy Worski on to talk about that. That was after his hiatus from the internet. I was not super familiar with him at the time. But I had him on the show. We talked. And then didn't really talk again for a while. And then during his fight with Tonka earlier this year, which Tonka ended up backing out of by being either incompetent or a raging pansy. One of those two. I had Tonka on the stream to discuss what actually happened, because I was hoping that he would have a better story than what the actual story was. Turned out to not be true. Or not be true that there was a better story. It was the lame story that we were presented with, and Andy came on my show at that time and yelled at Tonka, which was very funny. That's why he's in my intro. That's what that was from. You can check it out if you want. There's a Tonka stream, which is a good watch in general, I think, but I'm biased. And then I met him down in Knoxville for the supposed fight, which Tonka, of course, did not show up to. Andy was there. I got to hang out with Ethan Ralph, Coach Red Pill, and Dick Masterson. We had a good time. Other than that, after that, Andy basically fell off my radar. I mean, I talked to him on and off, but all offline other than that. But I haven't talked to him in a long time. I like Andy. I hope he's not gone crazy, and I wish him a lot of success. I'd talk to him again too, but I just haven't talked to him in a long time. Okay, hopefully that helps. Redacted says, what wheat beer is where it's at? Try Weinstefan. Nah, I'm good without beer in my life. Amenthi says, here's $5. Get yourself some strawberry milkshake Pop-Tarts. If you don't have them out there, I'll send you some. I've seen them. Are they good? I don't know. To Dark Chow says, if I'm not mistaken, a good amount of your sources are VAs, yes? I know you can't reveal them yet, but can we get a hint? California, Texas, both? No. No, you can't get a hint. I'm sorry. Everybody's in danger. Everybody's in danger from these people because they're disgusting. They're bad people who lie to get people ruined. So if I put out someone's name, they'll just lie to get them ruined. Moist John says, Nick, without allergies, you're going to squat and deadlift? Yes. Although I have noticed during the meager amount of work that I've done following the allergy shot that I do still have a little bit of a reaction. So I've got to test more to see how that goes. And it might just take a couple months for it to set in all the way. So we'll see. It's an ongoing experience for me. Stargirls Forever says, take my very first super chat. Hey, thank you. It's a blast watching you expound, educate, and enlighten, but mostly it's awesome watching you rant. Keep being you. Thank you very much. Basement Troll Production says, bad news. Vic's story at the mainstream. Marchi was interviewed by NPR, and they used a sound clip of you, Nick. Perhaps it's time to reach out to Fox News. Maybe get the Greg Gutfield show. Sure, maybe. Rick-U1186 says, Lemoine is too stupid to see the trap that everyone else sees. I haven't even been to law school and I see it. What a fool. And he follows up, Lemoine acts as if what he says is fact without basis for his arguments or any foundation for his claims and accusations. Sounds familiar. Tillip sent a salt sticker. Rick-U says, Lemoine, liar, liar, set his pants on fire. Julio Santoyo sends a gif of someone blowing a kiss. Thank you. Hawk Anime says, oh, the lies. Oh, the lies. Finn Frog says, legalese for violating No Nut November. Premature legal objeculations. Rick uses a sneeze on the sleaze as he leaves. Leet Man has a finger like this. Like this. Anthony Siebert has a, is that a hippo? Like a hippo rubbing his arm? I don't know what's going on there. Juro says, how's my favorite con slut doing? I have a free super chat and I wouldn't want it to go to waste. Say thank you. Mario Carter 13 says, but did you ride the Italian stallion in Hawaii? No. No, thank God, no. That's horrible. How dare you? Mad Lad says, I'm back, Nikki. Have my free super chat. Thank you. Keep doing what you do. Surprised nobody has called you Nick Rage Cage Rekieta. Bad Vibe says, Fantasy Soft supports Vic and DGAF about Kick Vic. Ron Crossman says, have Google's money. Any update on your boys' case? I'm waiting. I'm just waiting for the ruling from the magistrate, or the recommendation from the magistrate. It's been over 40 days. Just waiting to see what happens. As soon as it drops, man, I am ready to talk about it. It just hasn't dropped yet. CJ Henderson says, screw the anime community. It is a lie. I think that's showing to be a lie. Now, Random Blaze says, you'll find that all the Kick Vic side is trying to charge Vic for the court-ordered mediation fees, even though Chupp said the costs to be shared equally. Well, I think he said they were responsible for their own fees, but yeah. James Mansfield says, Spicer is nicer. Cheers. Hey, thanks, James. Josh Sharf says, I think no matter what happens, we as fans now know what these people are from trying to ruin Vic's life and won't be supported by the people anymore. Elemental Factor says, first time super chat. Keep up the great work. Hey, thank you very much. I appreciate it. Asphyxiation just sent a poop sticker. Thanks, I think. Zernabog 2720 says, take my free super chat money, Nick. Thanks. Big Red Bear says, if he gives them all the fees, wouldn't that in any way harm them in appeals court? No. Prometheus Zeta says, you know what the most messed up thing is? Vic's going through all this TCPA crap just to get the right to a fair trial. What kind of crap is this? It's the problem with anti-slap motions. It's the big problem with anti-slap motions. Oh, that's a lemon. It was a lemon blowing a kiss earlier. Gogger's Death Rattle says, if there's no protection under law against predation by online mobs, do we have to adopt a prison gang model? Joining one to avoid rape by others. No one knows what to do. We've got to have big companies and employers stop bowing to them. They're not that many people. Anthony Siebert says, free Medicare super chat funds from China YouTube. Hey, thanks, Anthony. Sean Clark says, I love the show. Keep up the great work. Freighter J sent a dancing lemon. It's on screen right now. Just degenerate and disgusting. And then Austin Heartless says, when are you going to get the join button? I asked YouTube about it. I've qualified for 6 or 7 months now. We'll see. All right, guys, that's what I've got for you tonight. Thank you for joining me. Thank you so much. I really appreciate it. Let's get the outro music. Did you guys say it was too quiet last time? Where is it? Oh my goodness. Hold on. I'll get it. That was my fault. Properties. That one. In high definition. Outro. There we go. Now. There's the music. Okay, Dark Foxen says, a summary of my thoughts to Lemoine's filings. Objection to form. Counsel, you need to behave. And then finally, Sergeant McSalty with the salt shaker. Thank you. Thank you, Sergeant McSalty. Okay, guys, I'm going to go grab some food from fridge or whatever. I'll see you over on Twitch if you want to come hang out. Should be fun. If you don't want to come hang out, I won't see you tomorrow, most likely, on YouTube. But I will see you Thursday or Friday. Peace. Peace. Welcome to Die. Sent a little waving cat raccoon thing. Thanks.
There's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an odd bag of bow, more of love rug. The spirits flow as the ones who get unemployed. So pour out a glass for the deposed on Twitter as we hear Lost Planning tonight. From the white shores of Nan to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, the guests are all plentiful, from Dante to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. Get unemployed. So pour out a glass for the deposed on Twitter as we hear Lost Planning tonight. From the white shores of Nan to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now.